Please hand over all the memos. You don't want it tomorrow? Please hand it over. Jack, check for you. If this memo is moved, check for you. ಯಾಕಂದ್ರೆ 5 ದಿನ 5 ಸತಿ ಮೂವ್ ಮಾಡೋದು ಚೆಕ್ ಮಾಡಿಸಿ Tomorrow. Yes. What is that you want? Tomorrow. It will come tomorrow. Yes, yes, ma'am. Say number. What? Nehru ಅಂತಿದೆ. The request of learned counsel for the petition list on. Yes, yes. So number 28. Yes, what do you want? Ian, amicus curiae time ಕೇಳಿದ್ರೆ ಹೆಂಗೆ? Not well. The request of the learned amicus curiae for the respondent list on. The 8 also. Is any objection? Huh? Petition has expired. The request of learned counsel for the petition list on. Yes. Yes. Sir, he is waiting before you. You came afterwards, isn't it? So have some decorum. Your time is equally valuable. His time is equally valuable. So don't dump him. Don't think you are important. Huh? Yes. 57. Request of learned counsel for the petition response also. Seal number? Yes. ಏನು offense? At the request of learned counsel for the petition list on. The request of learned counsel for the petition list on. Huh? Yes, Mr. 34. What do you want? NSC ಹಾಕಿದಾರ at the request of learned counsel for the petition list. ಏನು offense sir? List on. ಈಗಾಗಲೇ ಬಂದಿತ್ತಲ್ವಾ? The request of learned counsel for the petition list on. Next. Yes, Mr. Yes, what do you want? The request of learned counsel for the petition list on. Yes, Mr. Huh? Sir, if we are not called 26, we are still not at serial number 1. Please wait. बैठ जाओ, अब बैठ जाओ. Serial number? Petition list on. So, list on. Because the counsel petition list on. Correct.
Submission.
Please have somebody to tell you what is. Please wait, sir. We are at serial number 1. Don't ask for password in serial number 26. They still not reached serial number 26. Why do you? No, you rush up to portal number 2. I am not stopping you. 26 will come later. Please wait. Correct.
One submission, my lords.
2 weeks to do it. needful. Yes, madam, what is it?
Serial number 60, my lords, a week time may be granted, my lords.
60.
60, my lords.
Is at the request of Land Council for the petition this term. Next.
Much of.
Basavanna. 2 weeks time is granted to do the meeting. Ian Lokesh. What is maintainability? What is that? They have to challenge it in an appeal. Acquitted. Appeal after. To file an appeal. The petitioner has filed this revision petition. Challenging the judgment passed by the trial court in CC number 173 of 2019, acquitting the accused for the offences punishable under section 138 of the Negotiable Instruments Act. The proper remedy is to file an appeal and not a revision to section 397 of CRPC. The revision petition is dismissed as not maintainable. It is open for the petitioner to file appropriate appeal in accordance with law. Time consumed in pursuing this revision petition shall be enlarged while calculating limitation applicable to appeals. Next. Two weeks time is granted to do the needful. AP Loknath. There is no representation for the public. This term grateful. 2 weeks. Law counsel for the petitioner submits to the office of petition is complaint. Office is granted to verify, and if the office of petition is complaint, list the petition for admission. No. All right, it has to come up for admission. Yes. What is the offense?
Serial number 7, my lord.
Vehicle release. Early. Admission, but yes. Next. Yes.
Serial number 7, my lord.
Yes.
Matter get compromise, my lord. Already 80,000 rupees I already paid your honor. More than 2 weeks time, your honor, I reported the settlement, my lord. Notice servagide Swami. Petitioner ge notice servagide Swami. I am for the represent the petitioner council, my lord.
What is it you want to do?
2 weeks adjournment. Matter got settled, my lord. Already parties are amicably settled the matter, your honor. We have reported the settlement in the next state of hearing, your honor.
You will report settlement.
Yes, my lord. Already settled, my lord. Already 80,000 rupees part payment is paid.
You need 2 weeks to report a settlement which has already happened.
And further payment kodbek Swami avarige. Hangidre they have made application, necessary application.
ಎಷ್ಟು settle ಆಗಿದೆ?
ಅದರಲ್ಲಿ ಚೆಕ್ ಅಮೌಂಟ್ ಕೊಡಕ್ಕೆ ಏನೋ ಸೆಟ್ಲ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಅದಕ್ಕೆ 80,000 rupees already paid your honor.
What is the check? What is
check amount is a 2,60,000 amount.
Learned counsel for the petitioner submits that the parties have amicably settled the dispute, in terms of which, the respondent has agreed to receive a sum of rupees 2,60,000, which was the amount mentioned in the check. The learned counsel for the respondent, however, disclosed the same. The learned counsel for the petitioner therefore seeks time to report a settlement.
Already 80,000 rupees paid, your honor.
80,000 paid to whom?
For the respondent, yes, sir.
He also submits that pursuant to such settlement, the sum of rupees 80,000 is already paid to the respondent.
Yes.
This is however disputed by the learned counsel for the respondent. Thus, in order to enable the learned counsel for the petitioner to report a settlement based on 30th.
Much. Sir.
Furnishing of process fee, 1 week. 1 week to do the need. Huh? So what is this IA-1 for early hearing? Still the matter is not even admitted. We will permit him to withdraw then, subject to the result. Nodi heldalla, ಈಗ ನೋಡಿ ಹೇಳ್ಬೇಕು. You can't. This is check bounce case, mister. You can't. Please argue. Please. Forget that application. Argue on merits. Then we permit him to withdraw, subject to the result. How much is deposited? 1 crore. The learned counsel for the petitioner has deposited 50% of the fine amount, as ordered by this court on 23/3/2021. Full stop. An application is now filed by the learned counsel for the respondent for early hearing of the revision petition. Since the revision petition is not admitted, question of entertaining IA-1 of 22 does not arise. Hence, IA-1 of 22 is rejected. However, the amount in deposit before the trial court pursuant to the order dated so and so, is ordered to be released in favor of the respondent. This shall, however, be subject to the result of this revision petition. Yes. Complaints of office objections on IA. What is this for extension of time? Yes. Yes, how much time you want? Yes, madam. Any objection? IA-3 of 22 is filed for extension of time to deposit the 50% of the fine amount as 50% 50% of the fine amount as ordered by this court on 8/8/2022. So by the last chance, 1 week time is granted to do the needful. 50%. So in view of the 50% as ordered by this court, so in view of the cost shown for extension of time, the time for compliance is extended by 1 week. It is made clear that no further time shall be granted to comply the order. Stop. Then we'll release the amount to them. Subject to stop. If the amount is deposited by the petitioner before the trial court, the same shall be released to the respondent in accordance with law. Such release shall be subject to the result of this revision petition. Sir, you will get the copy tomorrow. Please apply it today, you will get it. Early hearing is Kashyap N. Naik.
My lord, I appear for the petitioner.
Yes, what is
Any date may be fixed. The offense is 468, 471, and 420, my lord. The allegation is that I have utilized some forged demand drafts. A2 is the person who has supposedly given me the demand draft. Split charge sheet was filed. I am still been convicted on the basis that I have not denied the forged document. Even though I have claimed I have had no knowledge, I have led my own evidence. I have stepped into the witness box personally to say A2 gave me the demand drafts. Any date, my lord. Any date may be fixed for final hearing. We are ready to argue.
Tomorrow.
Tomorrow, my lord.
You are ready?
Yes, ma'am.
IA-1 of 22 is filed for early hearing. The same is allowed. This the revision petition for hearing on 24th. ಯಾವ್ದು ಸೆಕೆಂಡ್ ಅಲ್ಲ? Yeah, furnishing of PF. Who appears for the executive? IA1 of 2019 is filed.
Not the finance informed, not yes.
Yes. Yes. Yes, challenge the sentence. Yes, challenge this. Insufficient. Right, who will accept notice in this? Criminal revision petition. Yaro. Nawaz. Mr. Nishit Kumar Shetty accepts notice for respondent number 1. Respondent number 2. Either Adil or Adil is yet to be implemented. Mr. You have substituted Adil with Nawaz. So put it out. Go through the revision petition. Please go through that. So who has to be substituted now? No, that's a mistake that you have committed. Now you have rounded off Adil's name and you have substituted Nawaz's name. So correct, but you have to undo it, no? Adinen tappan heng sari martare heli. How will you undo it? Could be the IA1 of. Now we have filed an application to again substitute Adil instead of Nawaz. So what do you want to do? Do you want to proceed against both the accused or only one of the accused? So therefore you want Adil to be back. If any objection, take a file, give a copy of the application. Serve a copy to both. Challenge HCGP is directed to serve copies of the application in IA number 1 of 2019 to Shri Nishit Kumar Shetty as well as Mr. Sachin BS, as well as a copy of the revision petition. IA 1 of 2018 for continuation delay of 196 days. Any objection? For what? Yes, ma'am. Any objection? IA 1 of 2018 is filed for continuation delay of 196 days in filing the revision petition. is stated in the affidavit accompanying the application that due to delay in procuring the opinion and forwarding it to the office of the ADGP, the revision petition could not be filed in time. The learned counsel for the respondent does not seriously oppose this application. Therefore, the cost shown for the delay is accepted and the delay of 196 days in filing this revision petition is condoned. Hence, IA 1 of 2018 is allowed. This is the revision petition for admission. Yes, IA 1 of 22 is filed by the learned counsel for the respondent for withdrawal of the amount deposited with the petitioner pursuant to the order dated 31/5/2021. The learned counsel for the petitioner has no objection for release of the amount, but submits that the same may be subject to the result of this revision petition. In view of the above submission, IA 1 of 22 is allowed, and the amount in deposit before the trial court pursuant to the order dated also is ordered to be released in favor of the respondent. However, such release shall be subject to the result of this revision petition. Yes. Harish Kumar. Any objection? What objection? Merits may held. Please argue on merits. Merits may held. What is the check amount? 10 lakhs. What is the transaction? And loan. Huh? Investment for company agreement. What is exhibit D1? LCR. What is the exhibit D1? What is the defense, mister? What is exhibit D1 then? All the exhibits you don't have, and still you have filed a revision petition. Nimatra no illa. We will permit him to withdraw, subject to the result. Again, 1 of 22 is filed by the respondent for release of the amount deposited by the petitioner pursuant to the order dated so and so passed by this court. Note here, please stop. The learned counsel for the petitioner seriously opposes this application and claims that there was no transaction between the petitioner as well as the respondent, and that the amount deposited is a sum of rupees 6.5 lakhs. Sum of rupees 5,07,000. He therefore submits that the respondent may be directed to furnish security to the satisfaction of the trial court to release the amount. Per contra, the learned counsel for the respondent submits the documents placed on record before the trial court establishes that the amount in question was given to the petitioner as a hand loan for business purposes, and therefore, the amount that is deposited by the petitioner may be released. Next para, in view of the fact that the trial court as well as the appellate court have confirmed the judgment of conviction for the offence punishable under section 138 of the Negotiable Instruments Act, the amount in question, amount in deposit in order to be released in favor of the respondent, which shall however be subject to the result of this revision petition. Hence, IA 1 of 22 is allowed. The amount in deposit is ordered to be released in favor of the respondent, which shall however be subject to the result of this revision petition. Yes. So 15 early, in the meanwhile, office is directed to secure the records. 16. Here for the what is the amount? 5 lakhs. 25. What is the transaction? Let him file his objection. There is no representation for the petitioner. To stop. The learned counsel for the respondent has filed the IA number 4 of 22 for release of the amount in deposit. As a last chance, 1 week time is granted to the petitioner to file objections to this application, failing which, the application will be taken up for disposal. What is this IA 3 of 22 for extension of time? In deposit madidara ilva? IA 3 of 22 is filed for extension of the interim order dated 21/6/2020. Since the petition has already deposited 50% of the fine amount, 40% of the fine amount, the interim order granted is extended in the next date period. List on date. Yes, Mr. Bhargav. Who has filed? Yes, any objection? 17 only. IA 2 of 22 is filed by the learned counsel for the response for release of the amount. Madam, let me one step partner. You want to jump all the stairs in one shot? Please wait. An application for release of the amount in deposit pursuant to the order passed by this court dated 2/6/2022. The learned counsel for the petitioner submits that the amount in deposit may be released, but however, the same should be subject to the result of this revision petition. In view of the aforesaid submission, IA 2 of 22 is allowed, and the amount in deposit before the trial court is ordered to be released in favor of the respondent, which shall however be subject to the result of this revision petition. 10% ಮಾಡಿ 50% ಮಾಡದೇ ಇದ್ರೆ execute ಮಾಡಿ. Please execute the order.
This entire petition and the claim of the respondent is we have challenged the police court in the and their 50% has already been deposited. And during they had tried to execute the article over at that point of time. Check they have filed.
What is the amount in deposit?
Deposit 4,80,000.
Before
this.
That is in MFA.
These checks were issued to take a.
Why was it dishonored then?
If that appeal is decided, this petition.
Then why were the checks dishonored then?
Lordship, it was taken forcibly.
Where is the question of force?
At the time of execution.
Where is the question of force? Everything is happening according to law. They have got an award.
50% has already been deposited. We have to.
When you file that,
50%, then it will go up.
you file this application at MFL. MFL file ಮಾಡ್ಕೊಳ್ಳಿ.
In MFO, they have already released. They have already withdrawn.
You already withdrawn.
They have withdrawn 4 lakhs. And the whole amount was 9 lakhs 80.
So what is to be withdrawn here?
It was the first certificate for 50,000 was withdrawn. They want to withdraw that.
Vardhakin, IA 2 of 22 is filed by the Learned Counsel for the respondent to withdraw a sum of rupees 52,000 deposited by the petitioner before the trial court. Full stop. The Learned Counsel for the petitioner has no objection for the same. In view of the same, IA 2 of 22 is allowed, and the amount of rupees 52,000 deposited by the petitioner before the trial court is ordered to be released in favor of the respondent. This shall, however, be subject to the result of this revision petition. Connectedly, same application. If you have connected, I will find another application. Put it 17.1. But that application is not posted, madam. Where is the application, madam? Where is the application? $611. I think it is not put up. Please go and check. It's not put up. Next. ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? You should make out some ground, mister. This is not a second appeal. ಏನ್ ಪ್ರತಿ ಸತಿ ನಾನು ಹೇಳಿ nobody seems to understand. This is not a second appeal. Revision ಏನ್ ground ಇದೆ ಹೇಳಿ? Point out some ground for revision under 397. ಆಯ್ತು on. ಅದಕ್ಕೆಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲಿಂದ ಕೊಡೋದು? Who has filled in the check? ಚೆಕ್ ಯಾರ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಅಲ್ಲಿ ಇದೆ? ಸರ್ ಅದನ್ನ ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡಿದೀರಾ? ಏನಂತ ಹೇಳಿದ್ರು ಓದು. Please remove that kerchief, mister. A kerchief ತೆಗೆದು. ಮಾಸ್ಕ್ ಹಾಕೊಂಬನ್ನಿ, ಇಲ್ಲ kerchief ತೆಗೆದು ಬಿಡಿ. ಅದೆಲ್ಲ ಕೇಳಿದ್ದು ನೋಡಿ. ಇದು ರಿವಿಷನ್ ಪಿಟಿಷನ್. ರಿವಿಷನ್ ಪಿಟಿಷನ್ ಅಂದ್ರೆ ರಿವೈಸ್ ಮಾಡೋದಕ್ಕೆ ಏನಾದ್ರು ಇದೆಯಾ ಸ್ಕೋಪ್ ಅಂತ ನೋಡೋದು ಅಷ್ಟೇ ಕೆಲಸ. 2 ಕೋರ್ಟ್ ನಲ್ಲಿ ನೋಡಿದ್ದಾರೆ, ನೋಡಿ ಕನ್ವಿಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಆ ಕನ್ವಿಕ್ಷನ್ ಕೊಟ್ಟಿರೋದು ಸರಿನಾ ತಪ್ಪ? ನಾಟ್ ಆನ್ ಫ್ಯಾಕ್ಟ್ಸ್, ಆನ್ ಸಮ್ ಪ್ರೊಸೀಜರ್ ಇರ್ರೆಗ್ಯುಲಾರಿಟಿ or some facts ನೋಡಿಲ್ದೆ ಏನಾದ್ರು ತೀರ್ಮಾನ ಮಾಡಿದ್ದಾರೆ ಆ ತರ ಇದ್ರೆ ಹೇಳಿ. ಅವರೇ ಬರ್ಕೊಂಡ್ರದ್ದು ಎಲ್ಲಿ ಕೇಳಿದೀರಾ ಅಂತ ಕೇಳ್ತಿರೋದು. ಏನಂತ ಓದಿ ಅದನ್ನ. So read it properly, mister. ಆಯ್ತು, ನಿಮ್ಮ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಏನಂತ ಹೇಳಿದ್ರ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಬಗ್ಗೆ? ವೆಂಕಟೇಶ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರಾ? ಮತ್ತೆ ಅವ್ರ ಪರವಾಗಿ ಇರುವಾಗ ಒಟ್ಟು ಕರೆಸ್ಬೇಕಲ್ವ ನೀವು? Notice regarding admission. So IA 2 of 22 is filed for dispensation of production of the certified copy of the judgment of conviction passed by the trial court. Since the same was placed before the appellate court, the production of the certified copy of the judgment of conviction in CC number so is dispensed. Hence IA 2 of 2022 is allowed. Issue emergent notice regarding admission. In the meanwhile, the judgment, this order of sentence passed, dated so and so, passed by so and so in CC number so and so is suspended, subject to the petitioner depositing 50% of the fine amount before the trial court, inclusive of the amount already deposited before the trial court, within a period of 2 weeks from today, full stop. Failing this, the respondent would be at liberty to execute the order of sentence in accordance with law. Upon such deposit, the same shall be released in favor of the respondent, which shall, however, be subject to the result of this revision petition. Yes. Welcome, Dave. Any objection? IA 1 of 22 is filed for consideration of delay of 195 days in filing the revision petition. The Lord HCGP does not oppose condonation of oppose this application. Hence, IA 1 of 22 is allowed, and the delay of 195 days in filing the revision petition is condoned. Yes, for suspension and what is the offense? How old are you? Petitioner was convicted for the offences punishable under section 279, 338, 337, 338, and 304A of IPC. 279 and 304A, read with section 192 and 196 of Motor Vehicle Act. To stop. The petitioner claims that the accident was not due to the negligence of the petitioner, but was due to reasons beyond his control, and that the trial court as well as the appellate court have not considered the spot measure, which indicates that the petitioner was not responsible for the accident. In that way of the matter, comma, the order of sentence dated so and so, passed by so and so, NCC number so and so, insofar as it relates to imprisonment of the petitioner for the offence punishable section 304A IPC is suspended. However, the petitioner shall pay the fine as ordered by the trial court in respect of the offences punishable in section 279, 304A, 192 and 196, 304A of IPC and 192 and 196 of MVC Motor Vehicle Act. The same shall be paid within a period of 2 weeks. What is the offence? To notice on IA 1 of 22 as well as on the main division. Yet first you pay the process, Mr. Same order. Madam, there's a delay, madam. I'm sorry. Next. Can't help it, madam. If you come belatedly, then notice has to be issued. Yes, next. Password. Mr. A.S. Gupta. Please get somebody to assist you. No, please get somebody to assist you. Not interested. No, please get somebody to assist you, sir. I can't convey. Please get somebody to assist. Pass over. Mr. Vijay Kumar Vairegowda. Quit ಆಗಿದೆಯಾ? Quit ಆಗಿದೆ. Finally, finally ಹಾಕಿದ್ದೀರಾ? Very good. Yes, Mr. Pass over. Mr. Rudraya. Yes. Password. Negro passport. So you ready? Good. An offense in. Who are the witnesses? Who is PW1? PW1 is the pillion rider. Who and three are eyewitness? Please wait. I don't know why you want to jump the gun. You know your case. I don't know your case. Let me understand. Yes, Jack. Owner of offending vehicle. PW8 is the IO. Complaint to spot marshal. Spot marshal is proved. Where is the sketch exhibit? It is marked, Mr. P11. Oh, wow. P11. Please wait, please wait. Yes. Width of the road is 40 feet, 18 feet. 18 feet.
Coming to the left side. Come to the right side, to go on the right side.
Then what is the justification for you to come on to the right side of the lane? KSRTC bus है या नहीं? Private bus. So you gone to the extreme right. Left side angry ಬಂದು ಹೊಡೆಯುತ್ತಾರೆ. Right side. What is the other vehicle? Two-wheeler. ಮತ್ತೆ? That is not the issue, Mr. There are two criteria. Number one, whether you are negligent. Number two, whether this accident could have been avoided. If accident could have been avoided, why you did not take steps? These are the three criteria. Adin ಹೆಂಗ್ establish? You are driving the vehicle. Why did you come onto the right side of the road is what I am asking. Is there any explanation for that? Correct, then you should justify why you came on the right side of the road. The right side is meant for the other traffic coming from the opposite direction. So why did you wander into the right side? There should be some justification, so therefore I had to come. There was a repair going on, so I had to come to the right. And this fellow suddenly came, we couldn't avoid. That is an accident. How have you explained that this was beyond your control? How have you established that there was a pothole? Have you cross-examined the IO? No, the IO cross-examined. Have you disputed the sketch number 1? So how you have disputed the sketch? In what manner? Huh? Let us see what you have extracted from the IO. IO is PW? What? Therefore, you are not suggesting that there is a pothole you wanted to avoid other in such spot. I PW1 spot was ಇನ್ನೊಬ್ರು ಇದಾರಲ್ಲ PW 6 both. PW5 ಹೋದ್ರಿ not PW6 PW5 The spot sketch is proved. We're not disputing the spot sketch. Yes. Yes. ಕಾರ್ಕಳದಿಂದ ಮೂಡುಬಿದಿರೆಗೆ ಬರುವಾಗ ರಸ್ತೆಯ ಬಲಬದಿಯಲ್ಲಿ ಬಸ್ಸು ಇತ್ತು ಅಂದ್ರೆ ಹೆಂಗೆ? ಅಲ್ಲಿಗೆ straight on to the right side lane. Karkala to Moodbidri, you know Karkala and Moodbidri. So the bus should be moving on the left side. Correct? From Karkala to Moodbidri, the bus will be moving on the left side. No. ಕಾರ್ಕಳದಿಂದ ಮೂಡುಬಿದ್ರೆಗೆ ಬರುವಾಗ ರಸ್ತೆಯ ಬಲಬದಿಯಲ್ಲಿ ಬಸ್ಸು ಇತ್ತು. ಆಯ್ತು, ನೀವು either way, whether it is coming from Moodbidri to Karkala or from Karkala to Moodbidri, should be on the left side of the road. Correct alva? Why it go on to the right side of the road? What? ಸ್ಮೃತಿ ತಪ್ಪಿತು. ಉಳಿದುಕೊಂಡು ಎಲ್ಲಿ ಕೇಳಿದ್ರೆ ಹೇಳಿ, ಎಲ್ಲಿ ಕೇಳಿದ್ರ for justification to stray into the right side, ಏನ್ justification? ಆಯ್ತು ಓದಿ, ಒಂದೊಂದಾಗಿ ಓದ್ಕೊಂಡು ಹೋಗಿ, ಏನ್ ತೊಂದರೆ ಇಲ್ಲ. You said PW2, you're not made any suggestion to PW2. Yes, PW1. ಅವರಾಗಿ ಬಂದು ನೀವಲ್ಲ ಅವರು, ನೀವು ತಪ್ಪಿಸ್ಕೊಳಕ್ಕಲ್ಲ, ಅವ್ರು ತಪ್ಪಿಸ್. Yes. Where's the justification? ಅಷ್ಟೇನಾ? ಎಷ್ಟು ಹೊಡೆದ ಪನಿಷ್ಮೆಂಟ್ ಬರ್ಕೊಳ್ಳಿ. Therefore, we'll put an end to this. Vote ಬರ್ಲಿ ಒಂದು ಅರ್ಥ. Accused is how many years old? 31 plus 13, 45. Let him not do this job again. Not for this offense. So you should prove, see, if you do not dispute that you are not there at the scene of the accident or you have been implicated, should prove that you have taken care, that you are not negligent, that you had taken all measures to avoid the accident. If you were there, if you are driving the bus and the accident did occur, you should establish that it is an accident, not due to your negligence. It was an accident, happens. I will prove on what. Mr. The fact that you strayed onto the right side lane is proof. Res ipsa loquitur. Right lane is for the other upcoming vehicles. How did you go on to the right side? There should be some justification why you went on to the right side. You must have said that yaro biddodru sudden agalli. So I wanted to avoid him, so I hit him. That is an accident. If you don't come up with a plausible defense, this is what happens. What forced you to go on to the right side is something that you have to explain. So long as you are driving the bus at that point in time, you have to prove that. And you are driving a bus, mister, you are expected to be more cautious. And this is a straight road. It's not a humpo road. There's a curve in illa. So you're expected to drive the bus cautiously. Very good. How is probation of offenders applicable? No. Yes, Mr. Yes. Very good. The petitioner has challenged the judge. All right, that will be set off. The petitioner has challenged the judgment of conviction. Passed by, dated 12/6/2009, passed by so and so in criminal case number 802 of 2006 for the offences punishable under section 279, 337, 304A of IPC. And the consequent sentence. Full stop. The consequent sentence directing the petitioner to pay a fine of ₹1,000 for the offences punishable in section 279 and 337 and 6 months simple imprisonment for the offences punishable in section 304A of IPC. The petitioner has also assailed the correctness of the judgment dated 12/8/2013, passed by the second additional district and sessions judge Dakshin Kannada, Mangalore, in criminal appeal 268 of 2009, by which the judgment of conviction and the order of sentence was upheld. Next paragraph. The petitioner was charged for the offences punishable section 279, 337, 304A of IPC. Full stop. The records disclose that the petitioner was driving a heavy passenger vehicle on 1/6/2006 between Moodbidri to Karkala, from Moodbidri to Karkala. Full stop. At about 3:45 p.m., when the bus reached Petavuradu, Belvai, it dashed against a motor bike, resulting in the instantaneous death of the bike rider. Full stop. The petitioner denied the charges and prayed that he may be tried. Full stop. The prosecution adduced the evidence of a pillion rider who was riding the motorcycle on the fateful day as PW1 and 2 eyewitnesses as PW2 and 3. Full stop. The motor vehicle inspector was examined as PW4, who deposed that the accident was not due to any mechanical failure of the vehicles. PW5 was the witness in whose presence a spot measure was drawn. And PW7 was the owner of the bus who deposed that it was the petitioner who was driving the bus on the date of the accident. Full stop. The prosecution marked exhibits P1 to P13. Full stop. The statement of the petitioner was recorded under section 313 of CRPC, who denied the incriminating evidence against him. However, he did not lead any evidence in defense. Next paragraph. Based on the oral and documentary evidence, the trial court held that the prosecution had proved the guilt of the accused beyond doubt. Full stop. It held that the petitioner had driven the vehicle on the extreme right side of the road and had dashed against the motorcycle Full stop. It therefore held that the petitioner was guilty of the offences and hence convicted him for the said offences and sentenced him to pay fine of ₹1,000 for the offences punishable under section 279 and 337 and to undergo simple imprisonment for 6 months for the offence punishable under section 304A of IPC. To stop. Being agreed with the said judgment of conviction and order of sentence, the petitioner filed criminal appeal 268 of 2009. To stop. The appellate court secured the records of the trial court, heard the petitioner as well as the prosecution and framed points for consideration. And in terms of its judgment dated 12/8/2013, dismissed the appeal and upheld the order of conviction and the sentence passed against the petitioner. To stop being agreed by the same, the present petition is filed. Next, the relevant counsel for the petitioner submitted that the accident was not due to the negligence on the part of the petitioner, but the deceased, in order to avoid a pothole in the road, strayed onto the right side and dashed against the bus, which was driven by the petitioner. Full stop. He further contended that it was raining on the said day and therefore it was difficult for the users of the road to identify the potholes, and thus the accident occurred without any negligence on the part of the petitioner. Full stop. He further contended that who has turned hostile. Further contended that PW3, who was one of the eyewitnesses cited by the prosecution, had turned hostile. To stop. Turned hostile, and therefore the case of the prosecution was not proved beyond any doubt. To stop. The learned counsel prayed that the petitioner may be kept on probation instead of sentencing him to simple imprisonment. Full stop. Per contra, the SCGP submitted that the spot sketch, which was proved by PW5, demonstrated that the road was 18 feet wide. 18 feet wide, and was an official road. Full stop. The vehicle in question, the bus driven by the petitioner, was a stage carriage, and therefore, the petitioner was bound to be traveling regularly, bound to be driving the bus regularly on this road. Full stop. He contended that the accident occurred on the extreme right side of the road, and therefore, the petitioner had strayed onto the right side of the road and dashed against the motorcyclist, and instantaneously, instantaneously killing him. Full stop. The SCGP therefore submitted that the evidence of PW1, the pillion rider, and the evidence of PW2, an eyewitness, as well as the evidence of the motor vehicle inspector demonstrates beyond doubt that the accident was due to the negligence on the part of the petitioner. Full stop. Insofar as the application of the Probation of Offenders Act is concerned, the current HCGP submitted that the provisions of the Act is not applicable to an offence under section 304A of the IPC. Next para, I have considered the submissions made by the learned counsel for the petitioner as well as the learned HCG. Next para. PW1 next paragraph. When the petitioner is charged for the offences under section 279, 337 and 304A of the IPC, it is bound, it is for him to establish that either he was not the person who was responsible for the accident and or that he was not negligent and that the accident in question occurred beyond due to a reason beyond his control. Full stop. The petitioner did not dispute the fact that he was driving the bus in question on the date of the accident. He also did not dispute the fact that the motorcyclist was killed in the accident that occurred on 1/6/2006. Full stop. PW1 categorically stated in his evidence that it was the petitioner who was driving the bus in a rash and negligent manner and dashed against the motorcycle, killing the rider of the motorcycle. Full stop. The petitioner did not extract any evidence from PW1 to establish that he was not traveling he was not riding pillion on the motorcycle on the fateful day. Also not established any, and also not extracted any contra evidence to disbelieve the evidence of PW1. Full stop. PW2 was yet another witness who deposed that he saw the accident occurring. Full stop. Though he claimed that the accident occurred about 100 meters away from the place where he was standing. He in his cross-examination categorically mentioned that he had seen the accident occurring. Full stop. He also deposed that it was the driver of the. He also deposed that it was the petitioner who was negligent and was responsible for the accident. Full stop. PW4 was the PW4 error. PW5 was the PW4 was the motor vehicle inspector who submitted his report at exhibit P4, which indicated that the accident was not due to any mechanical failure. The report of exhibit P4 would demonstrate that the right side, that the damages were found on the right side of the bus, thereby indicating that the bus had strayed onto the right side of the lane and dashed against the motorcycle. There was no justification offered by the petitioner to justify the vehicle moving on to the right side of the road. To stop. PW5 was the witness in whose presence a spot measure was drawn, and he too supported the prosecution and claimed that the bus strayed onto the and claimed that the bus was found on the right side of the road, while the bike was also found on the right side of the road. Full stop. The owner of the offending vehicle, namely PW7, deposed before the court that it was the petitioner who was driving the bus in question on the date of the accident. Full stop. Therefore, on an overall view of the evidence on record, it is evident that it was the petitioner who was negligent and who stayed into the right side, stayed into the right lane of the road and dashed against the motorcycle and caused the accident and caused the accidental death of the rider of the motorcycle. Full stop. In that way of the matter, comma, full stop, full stop. The contention of the petitioner that the deceased in order to avoid a pothole in the road, comma, moved his vehicle to the right side and thereby dashed against the bus, comma, is no justification as the petitioner did not make any, did not confront PW8 or PW5 about such a pothole in the road. Full stop. It was only suggested to PW1 that there were potholes on the road and that the deceased attempted to avoid those potholes and dashed against the bus. Full stop. The trial court as well as the appellate court have perused the evidence in great detail and have returned a finding that the petitioner was guilty for the offences punishable section 279, 337 and 304A of IPC and have therefore rightly concluded, rightly convicted the petitioner for the said offences. To stop insofar as the order of sentence is concerned, the trial court had ordered the petitioner to pay a fine of ₹1,000 for the offences punishable section 279 and 337 of IPC and rigorous imprisonment, simple imprisonment for a period of 6 months for the offence punishable section 304A of IPC. Having regard to the fact that the petitioner, having regard to the fact that the negligent driving of the petitioner has resulted in the death of person, the order of sentence passed by the trial court is just and proper and does not call for any interference by this court. Hence, this revision petition lacks merit and is dismissed. Next. Bhagwan. Huh? Simply?
Property unlawful.
Who appears for the respondent?
These matters coming under division of the IT. Until notice to the Division Security Commissioner, Head of Protection for
यार Mr. Abhinay here. Who appears? Railways carry that.
Our word is
Very good. CGSC. You can take it, accept notice. Yaar Shanti Bhushan, learned AST is directed to accept notice for the respondent. Counsel for the petitioner is directed to serve copies of the revision petition and all enclosures to Sri Shanti Bhushan. List on. Mr. This is a 2013 petition, so I will not grant 2 weeks time. He is a outside and inside and I think Mr. Cases have to be disposed of.
I'm not doing the return here. Our judgment is that they ready to make the payment. But ready to work on it. Our judgment is
ಯಾರು ಇಬ್ರು ಅರ್ಗ್ಯೂಮೆಂಟ್ ಮಾಡ್ತಿದ್ರಿ ಯಾರು?
So it is a covered judgment. I'm not going to
Sit down. Sit down. The senior is told that you should stand, is it?
I'm not going to return this person. It is a covered judgment is that.
Thank you. Please serve a copy.
Yes.
When do you
I'm
want?
not going to return.
Friday. 20th. 20ನೇ ತಾರೀಕು ಲಿಸ್ಟ್ ಆನ್ Friday. This Mr. Kalyan.
One of the land getting survey number 44. And the complainant is the developer who had entered into the agreement with the landowner and the approved. You watch it kindly, exhibit that even
Exhibit D1.
even not even the process examination.
Exhibit D1. Yes.
Permission of the case. E3. Read the complaint. Yes. But the site was sold one time for. Time to work is not before. This document was admitted by the government. The state consultant. State consultant. The other document. This is towards mediation of this. So just for not the case of the complaint.
So let us see what is the complaint. This promoter and developer was later made by the accused. (21) 2006. What is this 21 2006? For the layout mentioned above, towards that first and second payment, the accused is- So what is this 20th of January 2006? Where does he say that?
Last examination, even the paragraph of the complaint. Complaints of the judge to pay back amount of
Which is that sale agreement? Is this the one? Is exhibit the one which is mentioned in paragraph 4? Let us see what he says in cross-examination.
Cross-examination.
I have not produced the agreement of sale dated 21 2006.
But as on the data, ultimate data. Has been like by level. I will see it. Is one guy not new data.
Where is Mr. Ravi Kumar? So what is the meaning of this suggestion? It is true to suggest that since he did not act as per the terms of the agreement, we have settled the matter. ಏನು ಹಂಗಂದ್ರೆ ಅರ್ಥ ಏನು? Out of this 2,50,000, so then why was he made a party, confirming party? Was something had to pay to him?
Either marketing, the complainant and approach. He's one of the signatory to the agreement of saying.
Why did you make him as a confirming party?
Both developed there. He is the person who is the confirming party. It is an executive.
Where is the joint development then? There should be a joint development.
Complainant says that you should have to.
Correct.
Thing.
So it says, see, you are the vendor. Please wait. You are the vendor. Anil Kumar BK is the vendor. And Arya developers are the developers. And both of you join together and sell the site to somebody. Now some money had to be paid to the developer.
The confirming part.
ಯಾವ amount?
This amount what he says, because not directly paid to the accused. He says he had entered into several agreements, he has agreed to sell the property. The clients of the complainant for 9 to 10 agreements. Those who is for market.
What is your evidence? I think ನಿಮ್ಮ evidence here first. Let us see what is your evidence.
Discharging the burden upon the complainant.
Now, have you let in any defense evidence? ಅಂತ ಹೇಳಿದ್ರು vote. ಹೋಗಿ ಏನು ಹೇಳ್ತಾರೆ? Yeah, it may be true that more than 10 persons purchased the sites to the complainant. It is not true to suggest that the amount of rupees 2,50,000 received from the 10 persons at the time of purchase of the land. Witness again says, I do not remember to say the exact amount received from all the 10 members.
It is 10,70,000. Last 3 lakhs.
May be true that I have received more than rupees 10 lakhs from all of them. I have to verify as to on 24/9/2005, some of this 10 lakhs paid by the complainant. So check number so it is true to suggest 10 lakhs is paid by the complainant.
Years of the complaint, the word the agreement of paying is amount was paid. Now the course of transaction agreement and process nomination is one. The entire process of the complaint is
No, you admit that 10 purchasers through the complainant.
saying that.
So, 10 ಜನಕ್ಕೆ ನೀವು shared workout ಇಲ್ಲ.
Yes, that towards the agreement of say related to 2006. What's the payment of checks?
It is true to suggest that those 10 sites not sold in favor of a complainant or the persons brought through him. I did not read from, please wait. You don't have the cross examination, I am reading it for you.
I recently for the cross examination dated 10/7/2000. Part 3 line for next day. I did not recall the amount I got the complaint.
ಎಲ್ಲಿದೆ?
It is not the case of the complaint.
Correct, that is your defense.
Look, the complainant says, first of all, the complainant to prove. Here it has stated that that is one to the reason of just issued the check. Here he the promoter. He already entered into an agreement. What's repayment of the particular agreement of sale?
Yes.
It does not say that towards several agreements which are there when he received the amount and then after he has issued the check. What is
There's some transaction between the parties.
the transaction between here?
So you admit that 10 people came through the complainant to purchase sites.
It's an agreement of sale. And under the agreement of sale, he the confirming party.
Yes.
Who all executed.
Then why did you admit that 10 persons came through the complaint to purchase sites and that you are not sold? Sorry.
The legal notice was also made. Our client submits that we have issued checks to our client very in the number. For the agreement of sale dated 20 January 2000. My client was promoted on level. And in addition of the village, subsequently, our client promoted the level and sale was reduced in the between parties. Not in the class examination.
Please read. Don't word.
Thereafter, collectively huge amount of the purchasers from whom were promoted to our client. Not will also make anything. Thereafter, collecting huge amount of the purchasers does not say that we are here take the amount.
Yes.
Further unable to use the land, the refunded a small portion of the legal notice is under the This is your legal credit. The amount is not legal notice. But in the complaint, similar, the legal one. But he does not, he never produce the agreement of sale data 20 as valid. His consistent case is that, the amount is paid under the agreement of sale data valid program. This case is valid. He has not stated that, he has collected the money from this, and in turn he has paid it. That is not his case. His case under the agreement, he is not to be tried out, is that the accused has collected amounts from the purchasers. When it is collected from the purchasers are not.
No, Kalyan, sorry. Okay. What proposition? Yes, please. Yeah.
And the, how you worship the kindly for
Yes. PW1. Page number 4. Yes, please. Correct. Correct. 10 people.
10 people, that is not the case of the complainant. Nobody is.
Sir, he has said it very loosely. He said it. There is wrong drafting. What can be done? But he has loosely said it. He has loosely said it. No.
Produce some document. Evidence is that there were several arguments which were entered between the complainant and the court, and it is like.
When in 2009 in the pending is.
That is not the case.
The petitioner has challenged the judgment of conviction dated 28/10/2013 passed by the.
Initial burden is upon the complainant.
Correct, Mr. Why did you accept that how 10 seats are Maratha is our.
The complainant cannot succeed based on weakness of the.
Correct, correct. This is a quasi. This is not a pure criminal case. It's not like any other criminal proceeding.
But initial burden is upon the complainant.
Yes.
And there is something applicated, something said in the complaint.
There is some transaction between you and him. Number one. Please wait.
800 document of sale. Doesn't say.
Judgment of conviction dated so.
Cross-examination.
Produce ಮಾಡಬೇಕು ಬರ್ಕೊಳ್ಳಿ please allow me. Dated 5th of October 2012, passed by the 16th Additional Chief Metropolitan Magistrate in CC number 60963 of 2009 for the offence punishable section 138 of the Negotiable Instruments Act and the consequent sentence to pay a fine of rupees 10 lakh, 11 lakhs. 11 lakhs and in default to undergo simple imprisonment for 1 year. The petitioner has also asserted the correctness of the judgment of the appellate court dated 28/10/2013, passed in criminal appeal 25145 of 2013. 25145 of 2012. By which the judgment of conviction and the order of sentence passed to the trial court was upheld. Next paragraph. The complaint lodged by the respondent before the trial court discloses that the petitioner was the owner of certain land. Owner of certain land in Pili Shivale village, Gujarali Hobli, Bengaluru East Taluk, Bangalore. Full stop. He claimed that he had promoted a layout and he had promoted a layout by marketing the sites to various parties and thereafter the various parties, and that substantial sums of money were collected by such purchasers. However, such purchases which were paid to the petitioner. However, the petitioner was unable to register and convey the sites so formed, and he full stop. The petitioner is stated to have refunded a small portion of the amount in terms of a small portion of the amount of a sum of rupees 10 lakhs in terms of a check bearing number 800286 of dated 1/11/2008 and 800287 dated 1/12/2008 for rupees 5 lakh each. Stop. The respondent claimed that the said checks were dishonored due to insufficient funds when presented with his banker for encashment. Full stop. The respondent cast a notice of demand on 27/2/2009, which was served. However, the petitioner did not reply or repay the amount demanded in the notice of demand. Notice. Full stop. The respondent claimed that the petitioner had therefore committed an offence punishable under section 138 of the Negotiable Instruments Act and initiated prosecution of the petitioner. Full stop. The petitioner who was served with the process. Sorry. The sworn statement of the petition was recorded and CC number 60963 of 2009 was registered and process was issued to the petitioner. To stop. The petitioner appeared before the court and pleaded not guilty and claimed to be tried. To stop. The respondent was examined as PW1 and he marked exhibits P1 to P9. To stop. The statement of the petitioner was recorded under section 313 of CRPC and he denied the incriminating evidence against him. And rate and offer to lead defense evidence. Full stop. The petitioner was examined as DW1 and he marked a copy of the agreement of sale dated 20th of January 2006 as Exhibit D1. Full stop. Based on the oral and documentary evidence, the trial court held that the check in question was drawn by the petitioner towards discharge of a debt, namely towards reimbursement of the amount paid by the nominee purchasers of the respondent, and therefore, the said check was drawn towards discharge of a lawful debt, and due to the dishonor of the said checks, due to insufficient funds in the account, the trial court held that the petitioner had committed an offence punishable in section 138 of the negotiable instruments, and thus convicted him for the said offence and sentenced him to pay a fine of ₹11 lakhs. Full stop. Being agreed by the said judgment of conviction, the petitioner filed criminal appeal 25145 of 2012. Full stop. The appellate court secured the records of the trial court, and after hearing both the parties, framed point for consideration and thereafter disposed of the appeal and upheld the judgment of conviction passed to the trial court. Judgment of conviction and the order of sentence passed to the trial court. Being agreed by the same, the present revision petition is filed. Next, learned counsel for the petitioner submits that the complainant, that the respondent was one of the partners of a firm with which the petitioner had entered into an understanding, in terms of which, the firm was required to identify purchasers in whose favor, the petitioner had agreed to execute sale agreements. Full stop. He therefore submitted that the respondent cannot alone. He therefore submits that there was no liability between the petitioner and the respondent, and therefore, the respondent could not have launched prosecution for the offence punishable in section 138 of the Negotiable Instruments Act. Full stop. He also contended that the respondent did not place on record the agreement of sale dated 20th of January 2006, under which, a site was agreed to be conveyed in favor of the nominee purchasers of the respondent. Further, he contended that there was an inconsistency between the case as made out in the notice of demand issued by the respondent, as well as the private complaint lodged, and therefore, on these counts, the trial court as well as the appellate court ought to have rejected the case of the respondent, ought to have acquitted the petitioner from the offence punishable in section 138 of the Negotiable Instruments. Per contra, the learned counsel for the respondent submits. Learned counsel for the respondent submits that DW1 in the course of submits a petitioner in the course of his evidence had admitted that he had executed 10 agreements in favor of 10 purchasers who were nominated by the respondent, in whose favor separate agreements were executed. He also deposed that he had not executed any conveying the said properties in favor of the said 10 purchasers. Therefore, he contends that the checks in question were drawn by the petitioner towards discharge of the amounts payable to the said purchasers. Full stop. He contended that since the respondent had taken the responsibility of ensuring the conveyance of these 10 sites, the petitioner as well as the respondent had amicably settled the issue, in terms of which, the petitioner had handed over the 2 checks in question towards discharge of a sum of rupees 10 lakhs that was payable to the purchasers of the respondent. We therefore submitted that the judgment of conviction passed by the trial court and upheld by the appellate court does not warrant interference, as there is no illegality or irregularity committed by the trial court and the appellate court in considering the case. Next para. I have considered the submissions made to the learned counsel for the petitioner as well as the learned counsel for the respondent. Next para. Next para. The learned counsel for the petitioner did not urge any ground in respect of any procedural error committed by the trial court or the appellate court in recording in disposal of the case before it. Full stop. On facts, the learned counsel for the petitioner attempted to demonstrate before the court that there was no transaction between the petitioner and the respondent, and therefore, prosecution of the petitioner for the offence punishable under Section 138 of the Negotiable Instruments Act was unwarranted. Full stop. He also claimed that there was no transaction between the petitioner and the respondent. There is no transaction between the petitioner and the respondent, and therefore, the checks in question were not drawn towards discharge of any debt in favor of the respondent. Full stop. What needs to be considered? Sorry, the records disclose that the respondent claimed that the petitioner was owner of certain land in Shivale village, which he intended to develop. Sorry, Shivale village, Vidralli Hobli, Bengaluru East Taluk. Full stop. The respondent had promoted the sale of the sites formed in the said layout and had identified certain purchasers in whose favor, the respondent is stated to have executed certain agreements and had collected huge amount from the purchasers. Full stop. It is also claimed that the petitioner had failed to. Petition, please come to the private company, paragraph number 3. Para 3 na lodi. The English is not proper. I am only putting it in a proper perspective. Correct? So therefore, the language is not properly worded. So therefore, I am only putting it in a proper perspective to understand. Para 3 was you got it reverse. Accused and complaint. See, what can be done? The lawyer should be blamed for this, not the party. Correct, sir. You please ask your colleague whether he can understand this language that he has put in the pleadings. Why should the client be correct? Why should the client be responsible for this? No adverse inference. It's all mistake of a lawyer. It should not result in difficulty to the client. Sorry. Yeah, I think. It's also claimed that the petitioner failed to convey the sites so agreed to be sold under the agreements referred above. Consequently, a settlement was arrived at in terms of which, the petitioner had agreed to refund a sum of rupees 10 lakhs through two checks bearing number 8000286 and 8000287 dated 1/11/2008 and 1/12/2008 for rupees 5 lakhs each. Full stop. The evidence on record, more particularly the evidence of BW1, indicates that the petitioner had received a sum of rupees 10 lakhs, sum of rupees 20 lakhs from the respondent under the agreements of sale. Full stop. He also admitted that he had sold 10 sites. He had agreed to sell 10 sites formed in survey number 44. And also admitted that he had not conveyed those 10 sites in favor of the complainant, in favor of the respondent, or the persons brought by the respondent. He also admitted that he did not refund the amount either to the respondent or to the persons approached through the respondent. Full stop. The petitioner claimed that he had conveyed, the petitioner later claimed that he had conveyed 7 to 8 plots in favor of the clients of the respondent. However, no document of whatsoever nature was produced before the court to establish that he had conveyed the said 7 to 8 plots in favor of the clients of the respondent. Full stop. This evidence clearly demonstrates that the petitioner had received certain monies from either the respondent or from persons whom the respondent had nominated, in whose favor, separate sale agreements were entered into. In whose favor about 10 sale agreements were entered into. Full stop. The petitioner failed to conclude the transaction and convey the sites in favor of the said 10 purchasers. Full stop. It was in that context that the checks in question were drawn in favor of the respondent, and therefore, the petitioner had admitted his liability to the extent of 10 lakhs. And therefore, the checks in question are deemed to have been drawn by the petitioner towards discharge of a lawful debt. The petitioner did not dispute his signature found on these checks and did not dispute that the checks were drawn from his account. Therefore, it was imminent that the presumption under section 139 of the Negotiable Instruments Act had to be pressed in service against the petitioner. To stop the petitioner, having set out his defense by claiming that he had executed 10 side deeds in favor of the respondent and his nominee purchasers, ought to have established the same by producing the said sale deeds. Full stop. No effort in that regard was made, and therefore the petitioner failed to rebut the presumption as provided in section 139 of the Negotiable Instruments Act. The trial court and the appellate court have rightly assessed the evidence on record and have rightly held that the petitioner was guilty of the offences punishable in section 138 of the Negotiable Instruments Act, and therefore were right in convicting the petitioner for the said offence and sentencing him to pay fine of rupees 11 lakhs. There is no merit in this writ petition same in this revision petition, therefore the same is dismissed. Any amount in deposit is ordered to be released in favor of the respondent. Sorry, Mr. What prevented you from challenging? ನೀವು ಮಾಡಬೇಕಾಗಿದ್ದಲ್ಲ. Actually, you should have. He is a man with all the wherewithal to pay. Narrow compulsory, but see, you should have kept quiet. You should have kept quiet. You enter the witness box and you pulled it on yourself. Why did you? Partnership firm itta? You should have simply kept quiet. Nimgo ivrgenappa sambandha mugithu. You should have cross-examined on those lines. Partnership ಮುಖಾಂತರ ಕೊಟ್ಟಿದ್ದು ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಎಷ್ಟು ಕೊಡಬೇಕು ಅದರಲ್ಲೇ ಹೋಗಿರೋದು. Why did you pull it upon yourself? You crossing ನೀವು ಎವಿಡೆನ್ಸ್ ಡಿಫೆನ್ಸ್ ಇಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಲೀಡ್ ಮಾಡಿ ಹಾಳು ಮಾಡ್ಕೊಂಡು. No, but in view of the presumption, you are bound to come up with some kind of a defense. Yes. Moonshine defense anta bandbitide. You can't simply come up with some defense and say, "I'll prove murder." No. You are also expected to demonstrate. You are also expected to demonstrate how the checks went into his hand. Let ತೋರಿಸ್ಬೇಕು ನೀವು. Unless but why did you accept D1 then? D1 accept ಮಾಡಿದಿರಲ್ಲ. ಏನೋ ಅದೃಷ್ಟ ಅಷ್ಟೇ ಹೋಗಿ ನೀವು. Yes, ಅನುರಾಧ ಅರಸ್. What is the offense? Hello? Yes.
This part different versions. Later involvement so the court
Yes. How much time you need? How much time do you need? And then we'll ask all lawyers to leave. Why should they wait? All lawyers, you can leave. Come back at 2:30. Yes.
the cases are thinking parents behind. And that's what other person behind. This is the case. And the accident is case because of the passion. This is the custom. But your complainants, evidence.
Let us read the complaint first. Who is the complainant?
See the person who was driving behind the car.
Examined before the court. PW1. Yes. Yes, please.
ನಾನು ಏಕನೇ ಕ್ಲಾಸಲ್ಲಿ ವಾಸವಾಗಿದ್ದೇನೆ. ನಮ್ಮ ಬಾಬು ರಾತ್ರಿ ಸುಮಾರು 8 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ನಮ್ಮ ಜೀಪ್ ಮುಂದೆ ಮೋಟಾರ್ ಸೈಕಲ್ ಇಬ್ಬರು ಸ್ಕೂಟರ್ ಸಮೇತ ಕೆಳಗೆ ಬಿದ್ದಿದ್ದು, ಬಲರೋ ಜೀಪ್ ಇಬ್ಬರ ವ್ಯಕ್ತಿಯ ಮೇಲೆ ಹರಿದು ಸ್ವಲ್ಪ ದೂರ ಹೋಗಿ ನಿಂತಿತು. ತಕ್ಷಣ ನಾನು ನನ್ನ ಜೀಪನ್ನು ನಿಲ್ಲಿಸಿ ಹತ್ತಿರ ಹೋಗಿ ನೋಡಲಾಗಿ ಮೋಟಾರ್ ಸೈಕಲ್ ಸವಾರ ಹಾಗೂ ಇಬ್ಬರ ಸವಾರರು ತೀವ್ರವಾಗಿ ಪೆಟ್ಟಾಗಿ ರಕ್ತಸ್ರಾವ ಆಗಿತ್ತು. ತಕ್ಷಣ ನಾನು ಆಂಬ್ಯುಲೆನ್ಸ್ ಮಾಡಿ ಸದರಿ ಗಾಯಗಳನ್ನು ನೋಡಲಾಗಿ ಮಾಡಿದ ಜೀಪ್ ನೋಡಲಾಗಿ ಜೀಪ್ ಚಾಲಕನ ಹೆಸರು
ವಿಚಾರ ಮಾಡಿ
ಚಕ್ರವರ್ತಿ ಮೋಟಾರ್ ಸೈಕಲ್
ಚೀಫ್ ಚಾಲಕ
ಹೆಸರು ವಿಳಾಸ ತಿಳಿಯಲಿಲ್ಲ.
Yes.
What is important of this? And he does not say the vehicle overspeeded him. Over is not the case. He says he was also working in front of the vehicle in front of the or the highway.
What are whose evidence?
PW1. Complainant is PW.
Please wait. Yes.
I like ಹಾಗೂ ಕೆಳಗೆ ಬಿದ್ದ ಇಬ್ಬರು ವ್ಯಕ್ತಿಗಳ ಮೇಲೆ ಹಾರಿತು ಮುಂದೆ ಹೋಗಿ ನಿಂತಿತು. ಆಗ ನನ್ನ ವಾಹನ ಸೈಡಿನಲ್ಲಿ ನಿಲ್ಲಿಸಿ ನಾನು ಹಾಗೆ ರಸ್ತೆಯಲ್ಲಿ ಹೋಗುತ್ತಿದ್ದ ಒಬ್ಬ ಬಂದು ಆಂಬ್ಯುಲೆನ್ಸ್ಗಾಗಿ ಹಾಗೂ ಪೊಲೀಸ್ ಫೋನ್ ಮಾಡಿ ಘಟನೆಯ ಬಗ್ಗೆ ತಿಳಿಸಿದರು. ಬೈಕ್ನಿಂದ ಬಿದ್ದಿದ್ದ ಇಬ್ಬರು ವ್ಯಕ್ತಿ ತೀವ್ರ ತರಹದ ಗಾಯಗಳಾಗಿತ್ತು. ಆಂಬ್ಯುಲೆನ್ಸ್ ಅಂತ ಸಾಕ್ಷಿ ಸಾಕ್ಷಿ ರುಜು ಮಾಡಿ ಹಲವು ಜೀಪ್ ಚಾಲಕ ನನ್ನ ವಾಹನ ಕಿಲೋಮೀಟರ್ ವೇಗದಲ್ಲಿ ಮುಂದೆ ಹೋಗುತ್ತಿದ್ದ ಮೋಟಾರ್ ಸೈಕಲ್ ಸಾಕ್ಷಿ ಮನಸ್ಸಿನಲ್ಲಿರುವ ತಮ್ಮ ಸಾಕ್ಷಿ ಮನದೊಳನಲ್ಲಿರುವ ತಮ್ಮ ಕುಟುಂಬವನ್ನು ನೋಡಿ T2 ಇನ್ಪುಟ್ ಸಾಕ್ಷಿ ಅದೇ ರುಜುವನ್ನು ಅದೇ ದಿನ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಮಾಡುತ್ತಿದೆ. ಯಾವ ಕಾರಣಕ್ಕಾಗಿ ನನ್ನ ರುಜುವನ್ನು ನಡೆಯುತ್ತಿಲ್ಲ. ಪೊಲೀಸರು ಹೇಳಿದರು ಮೇರೆಗೆ ಅದೇ ರುಜುವನ್ನು ಮಾಡಿದ್ದೇನೆ. ನಾನು ಅಪಘಾತ ಸ್ಥಳದಲ್ಲಿ ಯಾವುದೇ ಮಾಡುವುದಿಲ್ಲ. ಅಪಘಾತವಾದ ದಿನ ಮಂಡ್ಯ ಮೈಸೂರು ಜೊತೆ ಇನ್ನೂ ಮಾಡಿ ನನ್ನ ಸಮಕ್ಷ ಮಾಡಿ ಅದಕ್ಕೆ ನನ್ನ ರುಜು ಮಾಡಿದ್ದಾರೆ ಅಂತ ನನಗೆ ನೆನಪಿಲ್ಲ ಮಾಡ್ತೀನಿ
Exhibit P2 is the seizure measure. Yes, vehicle seizure. P2 is not spot measure, madam. Seizure. Spot measure, huh?
as per the vehicle seizure ಮಾಡಿ time ಮಾಡ್ತಾ
Extra thing, what was the time of this measure? 11:20, 11:30. Yes.
ದಿನಾಂಕ 14/8/2019 ಶನಿವಾರ ನಾನು ಕಳೆದ 15 ವರ್ಷಗಳಿಂದ ನಮ್ಮ ಕಾರ್ಯದಲ್ಲಿ ಕೇಸಿನಲ್ಲಿ ಈ ಕೇಸಿನಲ್ಲಿ ಸಾಕ್ಷಿದಾರನಾಗಿ ನನಗೆ ಕನ್ನಡ ನನ್ನ ಎರಡು ವರ್ಷಗಳ ಸಾಮಾನ್ಯವಾಗಿ ಹಿಂದಿನವರಿಗೆ ಕಾಣುತ್ತಾ ಎಂದರೆ ಸರಿಯಿಲ್ಲ. ನಾನು ರಸ್ತೆ ಮಧ್ಯಭಾಗದಲ್ಲಿ ಬರುತ್ತಿದ್ದೆ. ರಸ್ತೆ ಡಿವೈಡರ್ ಇದರಿಂದ ಸರಿ. ಹೆದ್ದಾರಿಯ ಒಂದು ಭಾಗದ ರಸ್ತೆ ಸುಮಾರು 30 ರಿಂದ 40 ನಾನು ಮೈಸೂರಿನಿಂದ ಮೋಟಾರ್ ಸೈಕಲ್ ಮೈಸೂರಿನಿಂದ ಬೆಂಗಳೂರು ಹೋಗುತ್ತಿದ್ದ. ಮೋಟಾರ್ ಸೈಕಲ್ ಮೈಸೂರಿನಿಂದ ಬೆಂಗಳೂರಿಗೆ ಹೋಗುವಂತೆ ನನ್ನ ಬಲಭಾಗದಿಂದ 8 ಅಡಿ ಎಡಭಾಗಕ್ಕೆ ನಾನು 70 ರಿಂದ 80. This is important because both the vehicles are one behind one is one vehicle. It is not that they had a angular shape, angular view. Because one vehicle was behind the other. And the second thing is his vehicle. And it is not clear that the Bolero vehicle overtook.
Yes.
So 100 meters speed there, there is no difference. ಎಪ್ಪತ್ತರಿಂದ 80 ಕಿಲೋಮೀಟರ್ ನಾನು ಎಂದು ಹೇಳಲು ಆಗುವುದಿಲ್ಲ. ನಮ್ಮ ಮಾರ್ಗದಿಂದ ಯಾವ ವಾಹನ ಮಂಡ್ಯ ಸುತ್ತಮುತ್ತ ಟ್ರ್ಯಾಕ್ಟರ್ ಹಾಕಿ ಪಕ್ಕದಲ್ಲಿ ನಿಧಾನವಾಗಿ ಅಗಾಧವಾದ ನಂತರ ಪೊಲೀಸ್ ಸ್ಥಳದಿಂದ ಮೊದಲು ಬೊಲೆರೋ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಆರೋಪಿ ಆಗ ನನಗೆ ಮಾತನ್ನ ಗೊತ್ತಾ ಇತ್ತು. ಬಿಕಾಸ್ FIR ಅಲ್ಲಿ the name of the accused ನಾನು ಆರೋಪಿ ಬೊಲೆರೋ ಪೊಲೀಸರೇ ಠಾಣೆಗೆ ಬಂದು
What is this? Please read it again. Adina, ROP, ಗಾಯಾಳುಗಳನ್ನು. What is the defense?
ಟ್ರ್ಯಾಕ್ಟರ್ ಹಾಗೂ ಮೋಟಾರ್
Where is the IF? Is it?
male patient calling himself instead of running the age 32 years. Initial patient was treated and first document ಇದಕ್ಕೆ ಮುಂಚೆ ಎಮರ್ಜೆನ್ಸಿ ಆಗಿತ್ತು ಎಮರ್ಜೆನ್ಸಿ ರಿಜಿಸ್ಟ್ರೇಷನ್ ನೋಡಿದ್ರೆ ಡಾಕ್ಟರ್
Yes. Where is the IMV report?
PW Karnataka model. Two cases. Mechanical condition ಆದ್ಮೇಲೆ ಕೆಳಗಡೆ number of cases. ಅದಾದ್ಮೇಲೆ as far as 1398 registration number plate but press and damage. Motorcycle is as far as the Bolero Jeep is damage and comfort registration number plate and damage. As far as the motorcycle is concerned, front meter board, crash guard, handle were pressed and damaged. There, right indicator broken and damaged.
Yes.
That's a very simple. One vehicle bidaga, what happens to the vehicle has fallen? Right indicator on damage. Damage as far as the vehicle, that is Bolero and the vehicle is not seen. This has been even in the cross examination that we have. And one more thing is, in the evidence of PW1, he says the vehicle passed on the vehicle. Passed on the vehicle and the insured.
Yes.
And take the logic to the PW7 period.
Yes.
ಎರಡು ವಾಹನಗಳನ್ನು ರಸ್ತೆಯ ಮೇಲೆ
ತಾಂತ್ರಿಕ ಅಲ್ಲ ಯಾಂತ್ರಿಕ. ತಾಂತ್ರಿಕ ಬೇರೆ ಯಾಂತ್ರಿಕ ಬೇರೆ.
ಮುಂದೆ ಹೋಗುತ್ತಿದ್ದ ವಾಹನಕ್ಕೆ ಡಿಕ್ಕಿ ಮಾಡಿದ ಮೋಟಾರ್ ಮೂಲಕವಾಗಿ ಹೋದಾಗ ಮೋಟಾರ್ ಸೈಕಲ್ ಕಾರಣಕ್ಕೆ ಈ ತರದ ಯಾವುದೇ ಜಖಂಗಳು ಇಲ್ಲ. ಮೋಟಾರ್ ಸೈಕಲ್ಗೂ ಕೂಡ ಅದರ ಮೇಲೆ ಹರಿದು ಹೋಗುವ ಜಖಂ ಇದ್ದರೆ
Yes.
this is what it is from the IME. And the second witness was examined the same by the witness who also is done he also speaks that the three vehicles involved that in the examination sheet. Subject PW2 other ತರಗತಿ ಋತುವನ್ನು ಈಶಾನ್ಯ ತೀರ್ಪು ಈಗ 2 ವರ್ಷದ ಮುಂದೆ ಇನ್ನೂ ವಾರಗಳಲ್ಲಿ ಪೊಲೀಸರು ನನ್ನ ರುಚಿಕೊಂಡು ಮೋಟಾರ್ ಜೀಪು ಹಾಗೂ ಕಾರಿಗೆ ಅಪಘಾತವಾಗಿತ್ತು. ಪೊಲೀಸ್ ಹೇಳಿದ ಮೇಲೆ ರುಜು ಮಾಡುವುದಕ್ಕೆ ಯಾವ ಕಾರಣಕ್ಕೆ ಪೊಲೀಸ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಏನು ಅಷ್ಟು ಕೆಲಸ ಮಾಡಲ್ಲ. As important also injured and IU. That is PW2. PW3. ಅದೇ ಬುಡಕ ಹೋತಾನ ರಜಾನಿ ಇಲ್ಲೇ ಇರ್ತಾರೆ ಏನ್ ರೈಡರ್ ಮತ್ತು ರೈಡರ್ ಅಲ್ಲಿ ಇಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಡೇ ಅದೇ ಬುಡಕ ಹೋತಾನ ಬಾಮ ಸರಿ ಗೊತ್ತು ಆತ ಸದಸ್ಯ ದಿನಾಂಕದ ಸಂಜೆ 7:30 ಗಂಟೆಗೆ ಇಂದು ವಾರದಿಂದ ಸ್ವಲ್ಪ ಮಟ್ಟಿಗೆ ಬಂದಾಗ ಹೀಗೆ ಮಾಡಿದ್ದನ್ನ ಮಾಡಿದ ಹೆಚ್ಚಾಗಿ ನಾವಿಬ್ಬರು ನಮ್ಮ ಮೇಲೆ ಹಾಯ್ದು ಹೋಗಿ ನನಗೆ ಸುಂದರ ಭಾಗದಲ್ಲಿ ಎದೆ ಭಾಗದಲ್ಲಿ ಸೋನ್ಸೋ ಉಜ್ಜಿ ಹೋಗಿತ್ತು. ನನಗೆ ಪ್ರಜ್ಞೆ ಇರದ ಓದೋ ಬ್ರಹ್ಮಚಾರಿಯನ್ನು ಅದೇ ಅವರ ಆದರೆ ಓದೋ ಬ್ರಹ್ಮಚಾರಿ ಅವು ಏಕಮುಖದ ಸಂಚಾರಕ್ಕೆ ಒಂದೊಂದು ರಸ್ತೆಯಲ್ಲಿ 34 ಅಡಿ ಅಗಲವಾಗಿದೆ. ಮೋಟಾರ್ ಸೈಕಲ್ 20ರಿಂದ 30 ಇದು ಜಾಗದ ಹಿಂದಿನಿಂದ ನಾನು ಇಲ್ಲಿಯವರೆಗೆ ಜೀಪಿನ ಚಾಲಕನನ್ನು ನೋಡಿರುವುದಿಲ್ಲ. ಅಪಘಾತವಾದ ದಿನ ಆರೋಪಿಯ ಜೀಪನ್ನು ನಿಲ್ಲಿಸದ ಕಾರಣ ನಾನು ಆತನನ್ನು PW1 ಸ್ವಲ್ಪ ಮುಂದೆ ಹೋಗ್ಬಿಟ್ಟು ಇಮೇಲೆಲ್ಲ ಅಲ್ಲೇ ನಿಲ್ಲಿಸ್ತೇನೆ and the was taken.
Yes.
ಅದು ಒಂದು ಸೆಂಟೆನ್ಸ್ ಮಾತ್ರ ಅಪಘಾತ ದಿನ ನಾನು ಹೋಗಿದ್ದು ಕೂಡ ತರಗತಿ ದಿನಾಂಕದಂದು ನಾನು ಮೈಸೂರಿಗೆ ನನ್ನ ಹೆಣ್ಣು ಹೋಗುತ್ತೆ. ಮೈಸೂರಿನ ಬಿಟ್ಟಾಗ ನಾನು ಶನಿವಾರ ಹಾಗೂ ಭಾನುವಾರ ಒಂದು ವಾಹನವನ್ನು ಓವರ್ಟೇಕ್ ಮಾಡದೆ ಇರುವಷ್ಟು ನಾನು ಕಾರಣ ಬರುತ್ತಿದ್ದ ವಾಹನಗಳು ಕಾಣುತ್ತಿರಲಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಮೋಟಾರ್ ಸೈಕಲ್ಗೆ ಹಿಂದೆ ಹೊಡೆದ
ಟ್ರೈಲರ್ಗೆ ಅಲ್ಲ ಟಿಲ್ಲರ್ಗೆ
15ರಿಂದ 20 ಅಡಿ ದೂರ ರಸ್ತೆಯ ಮೇಲೆ ಉಜ್ಜಿಕೊಂಡು ಹೋಗಿರುತ್ತೆ. ಸ್ವಲ್ಪ ಮಾತಾಡಿದ್ದೆ ಆಂಬ್ಯುಲೆನ್ಸ್ಗೆ ಫೋನ್ ಮಾಡಿ ಕರೆದ್ರು. ನನಗೆ ಕಡಿಮೆ ಬಂದಾಗ ನಾನು ಎರಡು ಮೂರು ದಿನ ಹೇಳಬೇಕು ನಾನು ಪ್ರಜ್ಞೆ ಬಂದಾಗ ಇಲ್ಲ ನಮ್ಮ ಕಡೆ
Here's a sketch.
ಸಾಧ್ಯವಾಗದಲ್ಲಿ
ಇಪ್ಪತ್ನಾಲ್ಕು ಅಡಿ ರಸ್ತೆ.
ಅದು ಹದಿನೈದರಲ್ಲಿ ಒಂದ್ ಸೈಡ್ ಇಲ್ಲ ಸೊ ಇನ್ನೊಂದು ಕಡೆಯಿಂದ wherein the accident has taken place is about 15 meters. But the clear side of the last, not to the edge. And the person who gave evidence also considered entity from the evidence. This is what is seen in the case. What is disputed is one of the mother witnesses that this has been taken place in India. In fact, the other person says it has taken like P6.
Exhibit P6.
Mother. ಸಾಕ್ಷಿ ಸ್ಥಳವನ್ನು ತೋರಿಸ್ತಾರೆ ಈ ಎರಡು two different cases and one mother witness is in a different case. Mother witness is in a different case. ಎಲ್ಲರೂ ಸರ್ಕಲ್ ಹಾಗೂ ಹಾಗೂ ಸದರಿ ಸ್ಥಳ ಬೆಂಗಳೂರು ಮೈಸೂರು ರಸ್ತೆ ಪೊಲೀಸರು ಸ್ಥಳದಿಂದ ಸ್ಕೂಟರ್ ಹಾಗೂ ಕಾರನ್ನು ಪಡೆದುಕೊಂಡಿದ್ದರು. ಆಗ ಸಮಯ ರಾತ್ರಿ 10 ಹೋಗಿ ವಾಪಸ್ ಭೂಮಿಗೆ ಬರುತ್ತಿದ್ದೆ. ನಾನು ಸ್ಕೂಟರ್ ನನಗೆ ಗೋಧನ್ ಚಾಟಿ ಪೆಟ್ಟಿ ಅಂಗಡಿ ಇಟ್ಕೊಂಡು ಹೋಗ್ತೇನೆ. ನಮ್ಮ ಹತ್ತಿರ ಹೋಗಿದ್ದ ನಮ್ಮ ಎಲ್ಲಿಯೂ ಸರ್ಕಲ್ ಮಾರ್ಗವಾಗಿ ಬಂದು ಎಲ್ಲಿಯೂ ನನ್ನನ್ನು ಯಾವತ್ತೂ ಪೊಲೀಸರು ಕಾಣಿಸುವುದಿಲ್ಲ. ನಾನು ಸತ್ಯ ಹೋದಾಗ ಅದರಲ್ಲೇ ಇದ್ದರು. ನನಗೆ ಟ್ರ್ಯಾಕ್ಟರ್ ಇದ್ದ ಬಗ್ಗೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನಾನು ಸೇರಿಸಿ ಎರಡು ಮೋಟಾರ್ ಸೈಕಲ್ ಮೊದಲು ಪೊಲೀಸರು ಮಾತನಾಡಲು ಕರೆದಿದ್ದರು. ನಾನು ಮೊದಲು ಪೊಲೀಸರು ಮಾತನಾಡಲು ಕರೆದಿದ್ದರು. ಪೊಲೀಸರು ವಾಹನಗಳನ್ನು ತೆಗೆದುಕೊಂಡು ಹೋಗುತ್ತಿದ್ದೇವೆ, ಅದಕ್ಕೆ ಮಾತನಾಡುತ್ತಿದ್ದೇವೆ, ಏನು ಆಗುತ್ತಿಲ್ಲ ಎಲ್ಲರೂ ಸರ್ಕಲ್ ನಲ್ಲಿ ತಿರುಗಬೇಕು. ಸರ್ಕಲ್ ಬಗ್ಗೆ ಪೊಲೀಸ್ ಅಮಾನತು ಗೊತ್ತಿಲ್ಲ. So-called eyewitness do not give the statement. That three others. One is the company, two others. The complainant's version, he also registered one, though he is the company, not aware as to. He was the third witness is this was a very different case. He said the accident was between the scooter and a car. Does not even say it was between a bike and a jeep or bike and a car. Why I am stressing upon that is he is aware. He is aware that there is he said that it was between a the witness.
What is the date of the wound certificate? So this is
These examinations directly taken.
So read the chief examiner.
And here was a mother in a package informed wisdom, ಮೇಲ್ಭಾಗದಲ್ಲಿ ಆಗಿದ್ದು ಅದರ ಅಳತೆ ಈ ಸ್ಪೋರ್ಟ್ಸ್ ಇದರ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಈ ಮೇಲ್ಗಡೆ ಗಾಯಾಳುಗಳ ಪೈಕಿ 4ನೇ ಗಾಯ ತೀವ್ರ ಸ್ವರೂಪವಾಗಿದೆ 1 ರಿಂದ 3 ಗಾಯ ಸದರಿ ಗಾಯ ಈ ಕೇಸಿನಲ್ಲಿ ಗಾಯಾಳು ಎಂಎಲ್ಸಿಯಲ್ಲಿ ಆಧಾರದ ಮೇಲೆ ಗಾಯದ ಈ ಕೇಸಿನ ಗಾಯ ನೋಡಿ ಗಾಯ ಒಬ್ಬ ವ್ಯಕ್ತಿ ಒಂದು ಫ್ರಾಕ್ಚರ್ ಗೆ ಬಿದ್ದು second case that is to say the PW3
What about the postmortem report? P5. What does it say? PW5. Both on a brahmachari. All the ribs on the left side are fractured at the sternal end. left lung is collapsed, right lung is intact. Okay. All the injuries are anti-mortem.
In nature are fresh. TW9 आगे और निकला.
Yes. Yes.
So I and that's sorry. I know the patient. ಎಲ್ಲ ಗಾಯ ಮರಣ ಪೂರ್ವ ಮುಂತಾದ ಗಾಯ ಯಾವುದೇ ಒಬ್ಬ ವ್ಯಕ್ತಿ ದ್ವಿಚಕ್ರ ವಾಹನದ ಮೇಲೆ ವೇಗವಾಗಿ ಹೋಗುವಾಗ ಗಟ್ಟಿಯಾದ ಮಾಡಿದರೆ ಎದೆಗೂಡಿನ ಮೂಳೆಗಳು ಮುರಿಯುವ ಸಾಧ್ಯತೆ ಇದೆ ಹಾಗೂ ಆ ವ್ಯಕ್ತಿ ಕೆಳಗೆ ಬಿದ್ದ ಸೆಕೆಂಡ್ 10-20 ಅಡಿ ಎಳೆದುಕೊಂಡು ಹೋದಾಗ ಶವ ಪರೀಕ್ಷಾ ಎಂದರೆ ಸಾಕ್ಷಿ 3ರಿಂದ 5 ಮತ್ತು 8 ಗಾಯಗಳುಂಟಾಗುವ ಸಾಧ್ಯತೆ ಇದೆ ಎಂದು ಹೇಳುತ್ತಾರೆ. ದ್ವಿಚಕ್ರ ವಾಹನದ ಮೇಲೆ ಹೋಗಿ ಮುಟ್ಟಿಯಾದ ವಸ್ತುವಿನ ಗಾಯ starting on the road, then there was a vehicle that is as far as my client, that is the petitioner, he has reached the spot immediately after. He has stopped the vehicle to help him because ಹತ್ತರಿಂದ 12 ಅಡಿ ಕೇಳ್ಕೊಂಡು but the actual eyewitness was behind the vehicle does not discuss. He says it might have dashed into dash. The witness was right and whatever this has got a higher height than the spot. The visibility of the accident is not possible. That is given for this. And one more thing, one more aspect is the vehicle which has got the damages does not carry the vehicle the damage of the two-wheeler. Two-wheeler they now hold it. Chance we had it. There should have been a proportionate damage for the backside.
What if you're driving at 100 kilometers and the motorcycle is being ridden at maybe some 60 kilometers? So even if you touch the vehicle, it will go off road.
Yes, please. I do not dispute.
It will veer off the road.
My vehicle to say that it was driving in 100 vehicle.
I'm only giving an example, not case specific.
Yes. My vehicle was not in the speed. Assuming I'm not checking because but only for the sake of argument. My vehicle touched the vehicle. It is nothing is forthcoming except to that right side indicator also touch it.
ಸಾಕು ಅಂತ ಹೇಳ್ತಿರಲಿಲ್ಲ.
It was not that I was negligent. negligence. I was careful enough to drive my vehicle across the
And
track.
you please decide what defense you want to take. If you say that I reached the spot and I saw that there was already an accident and I tried to help the victims, that is different. That is a defense you have taken. So therefore, how do you prove the defense?
One more aspect I would draw attention. PW1 says one more person came to me. Neither he is arrayed as a witness, nor he is examined.
Yes.
Why that person was not examined? Why? That is
Yes.
helping the PW1. And the second thing is the PW3 who's injured. Why should he lie so much that he was unconscious? He did not see. If everything was as stated, but he said, because everything record
Yes.
that does not cover this. Both are in serious conditions. Collateral is 90. If it comes that is true that I had committed the accident, he would have said I have. And I rushed off to the place and it was not. That is not at all the case. The only persons who have witnessed the accident is two people. PW1 and PW3. PW1 says he saw that see the accident as demonstrated. And as far as PW3 is concerned, he gives a different version saying that he has not seen his paper. He is not aware of his paper because he was sitting. He was really sitting like this. He will not be aware as to what is happening. But the second version not has not much influence because as far as the previous one is I don't that. The person that is the police who received the complaint says that it was a written complaint the police station and in the police in the information I have already that there is a mention name of the
Yes. Complaint.
Clearly sees that it is an addition. Your Lordship notices that it is an addition. I'm not sure addition, but there is one suggestion that people putting on particularly each. That is why I did not see that as the first instance. Your Lordship sees the person has taken the FIR. He says, because the complaint was not the name of the these all shows that prosecution has made proof the case.
Yes. Yeah, I'll just give you a flip side. Suppose if you're taken a defense that this man was riding on the right side of the road while he should have been on the left side. So suddenly he came to the left side. So I couldn't control. Our defense thought it could have been different. Therefore, you've taken a defense which is virtually it is destructive to your own case. If you say that there was already an accident and you went there to help the victims, then your vehicle must have been parked on the side of the road. Correct. It should have been parked on the side of the road. Correct. It is not parked on the side of the road. It's not parked. Yes.
If you do Madhya district, if you are tractor traveling in the day, take on to God.
Who took him? Who took that person?
What PW1 says, he was the one who called the ambulance. The God, he is got the ambulance, ensure that the
Yes.
injured are got.
Yes, Mr.
PW1 is the remedy. They clearly said that no accident.
Yes.
He include witness PW3. PW3 is also what is there. This examination, I know something after 3 days, I asked. After that, I will say what happened. Like, very clear.
Yes.
Mentally, it is not marked. After that, we will-
Hmm.
it is admitted. There is no one. Can not be near.
Yes.
Anyone.
Yes.
Frequency and what is other is the rate.
No.
Peter with 7 Malad is there. Motor vehicle inspector. P4.
Oh.
P4 Malad is very seriously damaged. Lower vehicle is also damaged. P4.
Yes.
Nothing to say, only denied it.
No. Hmm. What is the cross examination regarding the involvement of the tractor, madam? To the IO. ಏನಂತ ಕೇಳಿದ್ರೆ ಟ್ರ್ಯಾಕ್ಟರ್ ಬಗ್ಗೆ read the cross examination.
PM ವರದಿಯನ್ನು ಅಧಿಕಾರಿ ಪರಿಶೀಲನೆ ಮಾಡುತ್ತಿದೆ. ಗಾಯದ ಮಾಡಿರುತ್ತೇನೆ. ಮುಂದುವರೆದು ತನಿಖೆಯ ಅವಶ್ಯಕತೆ ಇದ್ದರೆ ಮಾಡುತ್ತೇನೆ. My humble submission before the court is the first MLC report where the court got the information that you are not complete. If I had touched the vehicle in a very light manner also, because I was my humble submission is that does not tally with the vehicle. IMV report, it says that I had a very big bump in my vehicle.
Photographs illanడి photographs illa bump alla dent
And on the bumper. Yeah. Yes, I had that. That shows there should have a vehicle.
Now vehicle fully damaged. The motorcycle. ಮುಂದ್ಗಡೆ ಏನಾಗಿದೆ?
report ಅಲ್ಲಿ ಇದೆ ಮತ್ತೆ ಯಾರಿಗೆ
ಅಷ್ಟೇನಾ? Well, consider. All of the matters are 230. Yes. 39. 2014 sir, ಇದೆಲ್ಲ ಕಷ್ಟಪಟ್ಟು ಹಾಕ್ಸಿದೀನಿ. What percent? Sir, if you emotional submission ಮಾಡಿದ್ರೆ ನಾವ್ ಏನ್ ಮಾಡೋದು? And the request ಏನು offense ಏನು? Rigid ಇದೀನಾ? Am I rigid in 304A? And the request of the land council for the petitioner this one. Yes. G. Ravishankar Shastri. Party ನಿಮ್ದಲ್ಲ ಬೇರೆ ಕೋರ್ಟ್ ಬಂದಿದ್ದಾರೆ ನೋಡಿ. $45. Request of the land council for the petition list on Monday. 40? Yes, they are not a date for real. We'll list it tomorrow for dictation. What is the sentence imposed? 6 months. One year. Then we will consider reducing. Yes. Next. Huh? 32. Ah.
And there is no identity to be considered. The classification exam is very witnesses. Either one is the visitor, and either two is the part causer, either the three is the depend of the either four is the driver and either of the incident is stated as the number one claim and
So who identified accused number 1?
accused number one, there is no identification. What are the unity pro was working in the delivery land. Because the incident is taken place about 150 meters from the house of the land. PW4 is she immediately after the incident, she went and informed the PW4 that she not for the yes of the prosecution was working in the land, she came here and put the cloth on the face of it and strangled her and pushed her and outright the magistrate. She fell down. He taken the Mangal access, he run away. That is the reason of the prosecution.
Yes.
The Mangal was not. PW5, PW5 is the husband, the mother-in-law of the PW1. She informed him when he came home, she informed her. And PW 660 mother-in-law. PW7, the doctor examined the victim on the next day. There was all the injuries PW 8 is the constable who arrested the accused man 2017, 7 and 20 PW
16.
61. 61 2000. 61 he was arrested.
16 which year? 2007.
2008. 2008. Before PW10. They partly investigated. And the PW9 is the PSI who received who registered the case and partly investigated and preparing the charge sheet. Case registered on 10/12/2007. Upon offending section 394, 354. Initially, case was registered 392 and 354 ABC. And charge sheet was filed for 323 and 354.
Yes.
And PW9,
PW10.
PW10 is the one of the IO who visited the spot, conducted the spot master. During the course of the spot master, the road banks recovered. Number one. And the record statement of CW was there.
CW 1 to 10.
CW 4.
How does the trial court deal with this? Who are PW2 here?
PW2 is the spot master.
Punch witness.
However, PW2 cross examination police ನಾವು ಬರೆಯುತ್ತೇವೆ, ನೀವು ಸಹಿ ಮಾಡೋದು ಎಂದು ಹೇಳಿದ್ರು.
PW3 ಯಾರು?
PW3 husband of the PW1.
Husband of PW1.
PW4 is the mother, neighbor. Yes.
Now, who was identified this accused?
The person and the victim is also same village, only person, and the money.
ಅಲ್ಲ ಐಡೆಂಟಿಫೈ ಮಾಡಿದ್ದಾರೆ, ಮುಖ ಪಟ್ಟೆ ಹಾಕಿದ್ದು. Who saw this happening?
It says voluntarily says he did not have
ಯಾರು ಕೊಡಿ ನೋಡಿ, let us. Who is the complainant? PW1.
Read the subject.
Yes, please.
Even
ಒಂದು ನಿಮಿಷ.
stated that 10/2007. ಈ ಮೂಲಕ ಸ್ವಾಮಿ, ಈ ಮೂಲಕ ತಮ್ಮಲ್ಲಿ ಕೇಳಿಕೊಳ್ಳುವುದೇನೆಂದರೆ, ನಾನು ಲಿಂಗಾಯತ ಜನಾಂಗದ ಹೊಂದಿದ್ದು ನನಗೆ 35 ವರ್ಷ ವಯಸ್ಸಾಗಿದ್ದು ವ್ಯವಸಾಯದಿಂದ ಜೀವನ ಮಾಡುತ್ತಿದ್ದೇನೆ. ಹೀಗಿರುವಾಗೆ ನಾನು 5/12/2007 ಬೆಳಿಗ್ಗೆ ಇನ್ಸಿಡೆಂಟ್ ಆಗಿದೆ. 10:30 ಗಂಟೆಯ ಸಮಯದಲ್ಲಿ ನನ್ನ ಸ್ವಂತ ಜಮೀನಿಗೆ ಅಲಸಂದಿ ಹಿಡಿದು ಹೋದಾಗ ನಾನು ಒಬ್ಬಳೇ ಇರುವುದನ್ನು ನೋಡಿ ನಮ್ಮ ಗ್ರಾಮದವರನ್ನ ಚಂದ ಹನುಮಂತಪ್ಪ ವೀರಪ್ಪ ನಮ್ಮ ಜಮೀನಿಗೆ ಬಂದು ನಾನು ಹಿಂದೆನೆ ಬಟ್ಟೆಯನ್ನು ಒದಿಸಿ ಅಲ್ಕು ನನ್ನನ್ನು ನನ್ನ ಕೆಳಕ್ಕೆ
ಕುತ್ತಿಗೆ ಎಸಿಗಿ, ಇಲ್ಲದೆ ನನ್ನ ಕುತ್ತಿಗೆ ಎಸಿಗಿ
ನನ್ನನ್ನು ಕೆಳಗೆ ಮಾಡಲು ಯತ್ನಿಸಿದಾಗ ನಾನು ಕೂಗಿಕೊಂಡು ಒದ್ದಾಡಿದಾಗ ನನ್ನ ಒಳ್ಳೆಯಲ್ಲಿದ್ದ ಮಂಗಲ್ಯ ಬಂಗಾರದ ಚೈನನ್ನು ಇದು ಬಂಗಾರದ ಮಂಗಲ್ಯ ಚೈನ್ 35,000 ಚೈನ್ ನಾನು ನನ್ನ ಪಕ್ಕಕ್ಕೆ ಬಟ್ಟೆ ಉಳಿದಿದ್ದು ಸಿಗಲು ನೋಡಿದಾಗ ಬೇರೆ
ಓಡಿ ಹೋಗುತ್ತಿದ್ದಾಗ
ನಾನು ಜಮೀನಿಂದ ಊರೊಳಗೆ ಒಂದು ನಮ್ಮ ಗ್ರಾಮಕ್ಕೆ ಹತ್ತಿರ, ಅಂದರೆ ಮುಂಚೆನ ನಮ್ಮ ಗ್ರಾಮ
ಇಲ್ಲೇ ತೀರ್ಮಾನ ಮಾಡಿ.
ನಾನು ನಮ್ಮ ಗಂಡ ಇಬ್ಬರು ಗ್ರಾಮಸ್ಥರ ಕೇಳಿ ತುಂಬನೇ ಇದ್ದೆವು.
ಆ ದಿನದಿಂದ ಇಲ್ಲಿಯವರೆಗೂ ಗ್ರಾಮಸ್ಥ
ಮಾಡಲಿಲ್ಲ. ಅದಕ್ಕೆ ನನ್ನ
ಈ ದಿವಸ ಬಂದು ನಿಮ್ಮ ಪೊಲೀಸ್ ಠಾಣೆಗೆ
ಎವಿಡೆನ್ಸ್
PW1
ನಮ್ಮ ಮನೆಯಿಂದ
ನಿಮಿಷ what are the ಏನು ಗಾಯ ಏನಾಗಿದೆ? ಸ್ಕ್ರಾಚ್ ಮಾರ್ಕ್, right forearm, no bleeding, tenderness for the front of the neck, scratch mark for the right cheek, no other injuries found on the body. PW1
ನಮ್ಮ ಮನೆಯಿಂದ
ನಿಮಿಷ ತಾಳು. Yes, please.
ನಮ್ಮ ಮನೆಯಿಂದ ನಮ್ಮ ಜಮೀನು ಸುಮಾರು 100 ರಿಂದ 220 ಬರುತ್ತದೆ. ಸುಮಾರು 2 ವರ್ಷ ಬೆಳಿಗ್ಗೆ ನಾನು ಹೊಲದಲ್ಲಿ ಅಲಸಂದೆ ಹೊರಡುತ್ತಾರೆ. ನನ್ನ ಮಾನ ನನ್ನನ್ನು ಕೆಳಕ್ಕೆ ಬೀಳಿಸಿ ಅದರ ಒಪ್ಪಿಗೆಯಲ್ಲಿ ಸಿಗುತ್ತಾರೆ. ನನ್ನ ಪ್ರಾಣಿಯನ್ನು ಕಿತ್ತುತ್ತಾರೆ, ನಾನು ಕೆಳಗೆ ಬಿದ್ದಿದ್ದರೆ ನನ್ನನ್ನು ಬಿಡದೆ ಮೈ ಕೈಗೆ ಮಾಡಿರ್ತಾರೆ. ನನ್ನ ಮೂಳೆ ಇಲ್ಲಿ ಕೆಳಗೆ ಬಿದ್ದಿರ್ತಾರೆ, ನನ್ನನ್ನು ಬಿಡದೆ ಮೈ ಮಾಡಿರ್ತಾರೆ. ನನ್ನ ಮೊಣಕೈಗೆ ಬಾಯಿ ಕೊಡ್ತಾ ಇದ್ದರೆ ಈ ವಿಷಯ ಯಾರು ಎಂದು
ಭಾಷೆ
ಮನೆಗೆ ಬಂದಿರ್ತೇನೆ. ಈ ವಿಷಯವನ್ನು ಬಹಳ ಜನ ಡಾಕ್ಟರ್ ಮುಂದೆ ಆರೋಗ್ಯಕ್ಕೆ ಮಾಡಿರ್ತಾರೆ. ಈ ವಿಚಾರಕ್ಕೆ ಗ್ರಾಮಸ್ಥರು ತೀರ್ಮಾನ ಮಾಡುವಂತ ಎಷ್ಟು ಉತ್ಪಾದನೆ ತಿಳಿಸಿದ್ರು. ನಮ್ಮ ಮನೆಯಿಂದ ನಮ್ಮ ಜಮೀನು ಕೆಲಸ
ನಮ್ಮ ಮನೆಯಿಂದ ನಮ್ಮ ಜಮೀನಿನಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿರುವ ಸರಿ
ದಿನಾಂಕ 5 ಬೆಳಿಗ್ಗೆ ಸಮಯದಲ್ಲಿ ಇದೆಲ್ಲ ಡಿಲೇ ಮಾಡಿ
ಓದಿ ಪ್ಲೀಸ್ ರೀಡ್.
ಬಂದಿರಲ್ಲ ಅದನ್ನು ಮುಖ್ಯಕ್ಕೆ ಬಡದಿಂದ ಅಂದರೆ ಸರಿ ಇಲ್ಲ. ಎಲ್ಲ ವಿಷಯಗಳು ನಾನು ತಿಳಿಸಿರ್ತೇನೆ. ಎಲ್ಲ ಸೇರಿ ದೂರವನ್ನು ಯಾರು ಮದುವೆ ಗೊತ್ತಿಲ್ಲ. ಸಹಿಯನ್ನು ನಾನು ಹಾಕಿದ್ದೇನೆ. ವ್ಯತ್ಯಾಸ 2 ಸೈಡ್ ಪೊಲೀಸರು ಆ ದಿನ ಗೊತ್ತಿರಲಿಲ್ಲ. ಯಾವುದೇ ಸರಿ ಇಲ್ಲ. ನಮ್ಮ ಮನೆಯಿಂದ ಜಾಸ್ತಿ ಹೋಗೋದ್ರ ಜೊತೆ ಅರ್ಧ ಕಿಲೋಮೀಟರ್ ಇರುತ್ತೆ. ನನಗೆ ಜಾಸ್ತಿ ಹೋಗ್ಬಿಟ್ಟಿರ್ತದೆ. Written by
How does the trial court deal with this?
trial court. Listen at page, internal page, page 37. Trial court judgment.
I suppose.
ಅವು ಹೇಳಿಕೆ ಸಾಕ್ಷಿಯಾಗಿದ್ದು ಇದನ್ನು 4 ಹೇಳಿಕೆ ಸಾಕ್ಷಿಯಾಗಿದ್ದು ಇದನ್ನು 7 ವೈಜ್ಞಾನಿಕರು ಈ ಕೇಸಿನ ಸಾಕ್ಷಿದಾರ ಕೇಳಿರುವ ಪದ್ಮಾವತಿ ಅವರು ಸಾಕ್ಷಿಗಳಿಂದ ತಮ್ಮ ಮನೆಯ ತಮ್ಮ ಜಮೀನು ತುಂಬ ರೂ 200 ಅಡಿ ದೂರದಲ್ಲಿದೆ. ಈ ಸುಮಾರು 2 ವರ್ಷದಿಂದ ನಾನು ಹೊಲದಲ್ಲಿ ಕೆಳಕ್ಕೆ ಆ ಗಾಳಿಯನ್ನು ಕೆಳಕ್ಕೆ ಬಿದ್ದಿದ್ದರೆ ನನ್ನನ್ನು ಬೆಳೆದ ನನ್ನ ಮೈಕೈ ನೋವು ಉಂಟು ಮಾಡುತ್ತಿದ್ದರು. ನನ್ನ ಮನಕ್ಕೆ ಬುದ್ಧಿಗೆ ಗಾಯ ಉಂಟಾಗಿರುತ್ತದೆ. ಈ ವಿಷಯ ಯಾರಿಗೂ ಹೇಳಬೇಕು
Yeah, who are these stars of 4, 5, 6? Right, Modi.
ಆ ವಿಚಾರದಲ್ಲಿ ಗ್ರಾಮದ ತೀರ್ಮಾನ ಮಾಡೋಣ ಎಂದು ಸ್ಥಳಕ್ಕೆ ಬಂದು ಸ್ಥಳದಲ್ಲಿ ಮಾತಾಡಬಾರದು ನಿಮ್ಮ ಒಂದು ಪಡೆದಿರುತ್ತಾರೆ. ಅದನ್ನ ತಾಳಿ ಸಿಗಲಿಲ್ಲ, ಸಲಹೆ ತಾಳಿಯನ್ನು ಆಡಿ ಸಾಕ್ಷಿದಾರರಾದ ವಿಶ್ವಲಿಂಗಪ್ಪ ಅವರು ಸಾಕ್ಷಿ ಹೇಳ್ತಾ ತಮ್ಮ ಮನೆಯಿಂದ ಶಾಸಕ ಅವರ ಜಮೀನು ಅರ್ಧ ಕಿಲೋಮೀಟರ್ ದೂರವಿರುತ್ತೆ. ಗೊತ್ತಿರುತ್ತದೆ. ದಿನಾಂಕ 11 ಹೇಳೋದು ಬೆಳಿಗ್ಗೆ 11 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಶಾಸಕ ಜಮೀನು ಒಳಗೆ ಪೊಲೀಸರ ಬಂದು ಸ್ಥಳದಲ್ಲಿ ಮಾತಾಡಬಾರದು. ಒಂದು ಬೆಳೆ ಸಾಕ್ಷಿ ಜಮೀನಿಗೆ ಹೋಗಿ ಅಲಸಂದೆ ಬೀಸಿದಾಗ ಕಾಣಿದ್ರು ಕಳೆದಿದ್ದರು. ಭಾಷೆ ಕಾಣಿಸಿಕೊಳ್ಳಲು ಎಂದು ಅಲ್ಲ ಎಲ್ಲರಿಗೆ ತಾನು ಫಲಮಣಕೈ ಬಾಯಲ್ಲಿ ಗಾಯ ಉಂಟಾಗಿ ಊಟ ಮಾಡಲು ಆಗುತ್ತಿರಲಿಲ್ಲ. ತಾನು ಹೋಗಿ ಆರೋಗ್ಯ ಕಾಣಲಿಲ್ಲ. ನಂತರ ಗ್ರಾಮದ ಮುಖಂಡರಿಗೆ ವಿಚಾರಗಳನ್ನು ಪಂಚಾಯತರು ತೀರ್ಮಾನ ಮಾಡಿ ಸರವನ್ನು ಭಾರತದಿಂದ ಕೊಡಿಸುವುದಾಗಿ ತಿಳಿಸಿದರು. ಸರದ ಅಂದಾಜು ಬೆಲೆ ಸುಮಾರು 35,000 ಆಗಿರುತ್ತದೆ. 4 ಜನ ಆಸ್ತಿ ಕಳೆದುಕೊಂಡು ಹೋಗಿರುತ್ತದೆ. ನಂತರ ಪೊಲೀಸರಿಗೆ ಸದಸ್ಯ ವಿಚಾರವನ್ನು ನಂತರ ಮಧ್ಯಾಹ್ನ 2 ಗಂಟೆಗೆ ವಾಪಸ್ ಮನೆಗೆ ಬಂದಾಗ ಪಂಚಾಯತ್ ಮತ್ತು ಆರೋಪಿ ಪಡೆಯವರು ತನ್ನ ಮನೆಯ ಬೆಳೆದು ಬಂದಿದ್ದರು. ಆದರೆ ಆರೋಪಿ ಪೊಲೀಸ್ ವಿಚಾರಿಸ್ತಾರೆ
How does the appellate court deal with this? Para 35 will.
On considering this evidence of investigating officers with regards to classification of a court, does not see any inaccuracy in the sequence of investigation carried out by the officers. On considering the evidence of period 9 and 10, while elected officers and constables were apprehended the accused, court does not see that there is a powerful accused of the accused in the case. Therefore, from the investigation also, the prosecution is able to prove that the accused has committed the offense illegally. Therefore, from considering the areas on record about discussion of prosecution is able to establish the case that the accused they are reasonable doubt, but the accused has committed the offense illegally. PW1 is a definitely has stated that all the offense committed and the evidence is mother-in-law and mother-in-law of the PW1. Out of the evidence of the PW1 is always naked. Pushing the evidence also confidence of the court that the evidence has committed the offense legally. We must put that but very important to be completely evident. Not very the effort of the also writing a difficulty is established we are taking of the charges revenue therefore the effect of the system of central cost to the right to
Yes, Mr. But what about this? There's so much of variation from the complaint. So 5 days, actually it must have been well thought of. Correct ಆಗಿ ಯೋಚನೆ ಮಾಡ್ತಾನೆ ಕೊಡ್ಬೇಕು. Where's the recovery? Where's the recovery? ಮತ್ತೆ? But what about this delay for 5 days? Is that a justification? Correct, that's what. If it is a well thought of after 5 days, if it is if it has been reported after 5 days, Mr. The husband, she goes and informs the husband that he tried to molest her, he tried to commit outrage her modesty, and the husband keeps quiet for 5 days. Currently, will she? So on the same day, she comes and tells her husband, her mother-in-law, and her brother-in-law. And he waits for 5 days, is it? Correct, and the husband waits for 5 days. Correctly, how can you wait for 5 days?
Respect to the leaders also, really waited. No, immediately after that,
ಅಷ್ಟೇನಾ? It's better say 354 ಏನಿದೆ? Yes, for 354 and 323 ಇಲ್ಲ 354 ಗೆ for 354 354 ಏನ್ ರಿಕವರಿ?
The intention is to rob the.
Intention was not to rob, it was only incidental. Robbery ಗೆ ರಿಕವರಿ ಇಲ್ಲ, but 354 ಏನು? 354 ಹೇಳಿ, even if you touched her and she has explained the delay, 354 323 ಇಲ್ಲ, okay, 354 ಹೇಳಿ. ಎಷ್ಟು ವರ್ಷ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? What is the minimum sentence? Shall not be less than 1 year. Any other villagers are examined? PW4 ಏನ್ ಹೇಳ್ತಾರೆ ನೋಡಿ. PW4 ಏನ್ ಹೇಳ್ತಾರೆ? ಹಾ,
ನಮ್ಮ ಜಮೀನು ಶಾಸಕರ ಜಿಲ್ಲೆಯಲ್ಲಿ ಸುಮಾರು ದೂರವಾಗಿದೆ. ಇತ್ತೀಚಿನ ಘಟನಾ ದಿನಾಂಕದಂದು ನಾವು 300 ಕೋಟಿ ಓದಿದೆ. ನಾನು ಈಗಾಗಲೇ ಶಾಸಕ ಒಂದು ಹೋಗುತ್ತಾ ಬೆಳಿಗ್ಗೆ ಘಟನೆ ಬಗ್ಗೆ ಪೊಲೀಸರಿಗೆ ಅದೇ ಪಕ್ಕದಲ್ಲಿ yes, except this no other indicated cases.
ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಓದಿರಲ್ಲ, ಎಲ್ಲ ಅರ್ಲಿಯರ್ ವಾಸ್ ವರ್ಕಿಂಗ್ ಅಂತ. He was working with PW5 ಯಾರು? PW3 ಓದಿ ಏನ್ ಹೇಳ್ತಾರೆ?
ಈ ಫಸ್ಟ್ ಇದೆ ಶೀಕಲಿ ಇದೆ ಶೀಕಲಿ ನಾನು ಪೂರ್ತಿ ಮಾಡಿ ನನಗೆ ಜಾಸ್ತಿ ಕುಟ್ಟ ಇರ್ತದೆ. ನಮ್ಮ ಮನೆಗೂ ನಮ್ಮ ಮನೆ ಜಮೀನಿನಲ್ಲಿ ಇರ್ತದೆ. ಬೆಳಿಗ್ಗೆ ನಾನು ಕೆಳಗೆ ನಾನು ಮನೆಗೆ ಚೆನ್ನಾಗಿ ನನಗೆ ಜಾಸ್ತಿ 5 ಮತ್ತು ತಿಳಿಸಿ ಜಾಸ್ತಿ ಬೆಳಿಗ್ಗೆ ಭಕ್ತರು ಕಟ್ಟಾಲು ಕರೆದಿದ್ದರು.
ಆತ ಮೊದಲೇ ಹೋಗಿ ನಮ್ಮ ಜಮೀನಲ್ಲಿ ಅವಿತು ಕುಳಿತಿದ್ದಾನಂತೆ. ಹ್ಮ್ 354 ಏನ್ ಮಾಡ್ತಾರ? Relation is explained. Natural. The revision petition is dismissed. Sorry, the revision petition is allowed in part. The judgment of conviction passed by so-and-so. Judgment of conviction dated so-and-so. Passed by the so-and-so. In CC number so-and-so. Insofar as it relates to the offense under section 323 of IPC and the consequent sentence. $323 ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ and the consequent sentence to sentence to undergo simple imprisonment for 6 months is set aside. However, conviction of the petitioner for the offense under section 354 and the consequent 354 of IPC and the consequent sentence to undergo 1 year simple imprisonment is upheld. Mr. Mohan Mahabaleshwar Bhatt. There is no representation for the petitioner. Mohan Mahabaleshwar Bhatt.
I'm online.
Yes, good again. Yes, Mr. What is the offense?
138 more.
Yes. Yes.
Yes. But the petitioner is accused convict for the offense under section 138 more. He has been sentenced to pay a fine of rupees 82,000. But case of the respondent is that the petitioner has borrowed a. He never say even borrowed in his affidavit evidence. He says the my lords may kindly see his evidence in chief.
Okay, then. Yes, please.
Evidence is by way of affidavit, my lord. The chief examiner was para 2. I say that the accused owes a sum of 76,000 to me, and to discharge the said liability, the accused had issued a check number so and so Bangalore. I say that the accused has promised to honor the said check on 23/10/2005 or whenever presented for collection. This is all the allegation is. Now, kindly come to DW2, who is a bank manager who has been examined.
What is your defense?
My defense is that, Murad, I have not given the check for amount of rupees 76,000 at all. Kindly see, Murad, bank DW2, Murad, the manager of the bank. One Ravindranath Bagalgodi.
Yes. Yes, please. October
18/5/2010, my lord.
Yes.
ಅಕ್ಟೋಬರ್ 2005ನೇ ಇಸ್ವಿಯಿಂದ ನಾನು ಕರ್ನಾಟಕ ಬ್ಯಾಂಕ್ ಮಂಗಳೂರು ಬ್ಯಾಂಕ್ನಲ್ಲಿ ಹಿರಿಯ ಶಾಖಾಧಿಕಾರಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತೇನೆ. ಆರೋಪಿಗೆ ಸಂಬಂಧಿಸಿದ ಸಾಲದ ಖಾತೆ ಮತ್ತು ಉಳಿತಾಯ ನಮ್ಮ ಬ್ಯಾಂಕಿನಲ್ಲಿದ್ದು. There are 2 accounts, Lord, which is in the same bank. ನಿಶಾನೆ P1 ಚೆಕ್ಕಿನಲ್ಲಿ ಕಾಣಿಸಿರುವ ಖಾತಾ ನಂಬರ್ 1327 ಆರೋಪಿಗೆ ಸೇರಿದ ಖಾತೆಯಾಗಿರುತ್ತದೆ. ಆರೋಪಿಗೆ ಸಂಬಂಧಿಸಿದ ಚೆಕ್ಗಳು ನಮ್ಮ ಶಾಖೆಯಲ್ಲಿ ಅಮಾನ್ಯಗೊಂಡಿದೆಯೋ ನಿಶಾನೆ D1ರಂತೆ ಆರೋಪಿ ಖಾತೆ ಹಣವನ್ನು ಪಾವತಿ ಮಾಡದಂತೆ ಕೊಟ್ಟಿರುವ ಪತ್ರ ಅಂದರೆ ನಿಶಾನೆ P1 ಚೆಕ್ಕಿನ ಬರವಣಿಗೆ ಮತ್ತು ಸಹಿಯಲ್ಲಿ
ಸರಿ ಅಂದರೆ ಸರಿ. You are missing that word ಸರಿ.
No, D1 is ಸರಿ, my lord. That is the stop payment receipt that I have given, my lord. Next, my lord. ನಿಶಾನೆ P1 ಚೆಕ್ಕಿನ ಬರವಣಿಗೆ ಮತ್ತು ಸಹಿಯಲ್ಲಿ ವ್ಯತ್ಯಾಸ ಇದ್ದ ಕಾರಣ ನಾವು ನಮ್ಮ ಶಾಖೆಗೆ ಆರೋಪಿಯನ್ನು ಬರಲು ಹೇಳಿದ್ದೆವು. Then, my lord, crosses it. That is exactly is my defense. No, I never issued this check with this amount to this person at all. Now, kindly see, he was cross-examined, the bank manager. The third line from the top, my lords. ನಮ್ಮ ಶಾಖೆಯಲ್ಲಿ my lords,
Yes.
ನಮ್ಮ ಶಾಖೆಯಲ್ಲಿ ಹೆಚ್ಚು ವ್ಯವಹಾರ ಮಾಡುವವರ ಪರಿಚಯ ನಮಗಿರುತ್ತದೆ. ಆರೋಪಿಗೆ ಸಂಬಂಧಿಸಿದ 3 ಖಾತೆಗಳು ನಮ್ಮಲ್ಲಿ ಇದ್ದು, ಆರೋಪಿಯ ಉಳಿ ಖಾತೆ ನಂಬರ್ 1327 ಆಗಿರುತ್ತದೆ. ಉಳಿದ ಉಳಿತಾಯ ಮತ್ತು ಠೇವಣಿ ಖಾತೆಯ ನಂಬರ್ ನನಗೆ ನೆನಪಿಲ್ಲ. ದಿನಾಂಕ 27/10/2005 ಚೆಕ್ಕಿನ ಬರವಣಿಗೆಯಲ್ಲಿ ವ್ಯತ್ಯಾಸ ಇದ್ದ ಬಗ್ಗೆ ಆರೋಪಿಯನ್ನು ಬ್ಯಾಂಕಿಗೆ ಬರಲು ಸುಮಾರು 10 ಗಂಟೆ 5 ನಿಮಿಷಗಳಲ್ಲೂ ದೂರವಾಣಿ ಕರೆ ಮಾಡಿದ್ದೆವು. ಆರೋಪಿ ಯಾವ ಚೆಕ್ ಕಳೆದು ಹೋಗಿದೆ ಎಂಬ ಬಗ್ಗೆ ನಂಬರ್ಗಳನ್ನು ನಮೂದು ಮಾಡಿ ನಮಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಸದರಿ ಪತ್ರವನ್ನು ಆರೋಪಿಯ ಸಂಸ್ಥೆಯ ಲೆಟರ್ ಹೆಡ್ಡಿನಲ್ಲೋ ಅಥವಾ ವೈಯಕ್ತಿಕವಾಗಿ ಬಿಳಿ ಹಾಳೆಯಲ್ಲಿ ಬರೆದು ಕೊಟ್ಟಿದ್ದಾರೋ ಎಂಬುದನ್ನು ನಾನು ನೋಡಿ ಹೇಳಬೇಕು. ಆರೋಪಿ ಒಂದು ಚೆಕ್ ಕಳೆದು ಹೋಗಿದೆ ಎಂದು ನಮಗೆ ಪತ್ರ ಕೊಟ್ಟಿದ್ದರು, ಆದರೆ ಚೆಕ್ಕಿನ ನಂಬರ್ ನನಗೆ ನೆನಪಿಲ್ಲ. ಒಡ್ಡಿ ಖಾತಾ ನಂಬರ್ 1327 ಖಾತೆಗೆ ಸಂಬಂಧಿಸಿದ ಚೆಕ್ ನಗದೀಕರಣಕ್ಕಾಗಿ ಬಂದಿತ್ತು. ಆರೋಪಿ ಚೆಕ್ ಕಳೆದು ಹೋದ ಬಗ್ಗೆ ನಮಗೆ ಕೊಟ್ಟ ಫಿರ್ಯಾದನ್ನು ಎಷ್ಟು ಗಂಟೆಗೆ ತೆಗೆದುಕೊಂಡಿದ್ದೇನೆ ಎಂದು ಗೊತ್ತಿಲ್ಲ. ಸದರಿ ಆರೋಪಿ ಕೊಟ್ಟ ಫಿರ್ಯಾದಿನಲ್ಲಿ ಎಷ್ಟು ನಮೂನೆಯ ಸಹಿಗಳನ್ನು ಆರೋಪಿ ಮಾಡಿದ್ದಾರೆ ಎಂದು ನೋಡಿ ಹೇಳಬೇಕು. ನಮ್ಮ the very check itself is having so many discrepancies, but when it is presented by the respondent.
Read the evidence of DW1.
The learned magistrate.
Please read the evidence of
DW1, my lord. DW1, my lord.
DW1, D for Delhi.
Yes, please. Abdul Salam, my lord. ನಾನು ಕಾಂಟ್ರಾಕ್ಟರ್ಗೆ ಮಹಾನಗರ ಪಾಲಿಕೆಯಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೇನೆ. ನನಗೆ ಫಿರ್ಯಾದಿದಾರರನ್ನು ನೋಡಿ ಪರಿಚಯ. ನನ್ನ ಮತ್ತು ಫಿರ್ಯಾದಿದಾರರ ನಡುವೆ ಯಾವುದೇ ಹಣಕಾಸಿನ ವ್ಯವಹಾರ ನಡೆದಿಲ್ಲ. ನಾನು ಫಿರ್ಯಾದಿದಾರರಿಗೆ ಯಾವುದೇ ಚೆಕ್ ಅನ್ನು ಕೊಟ್ಟಿಲ್ಲ. ನನ್ನ ಮತ್ತು ಫಿರ್ಯಾದಿ ನಡುವೆ ಫಿರ್ಯಾದಿ ನಮ್ಮ ಮುಖ್ಯ ವಿಚಾರಣೆ ಹೇಳಿರುವಂತೆ ಯಾವುದೇ ಹಣಕಾಸಿನ ವ್ಯವಹಾರ ನಡೆದಿಲ್ಲ. Lords, can I read the cross-examination or entire deposition?
Read the first chief examination letters.
Yes, my lord. Cross-examination, my lord. Kindly turn to next page, my lord.
So you know the complainant. ನನಗೆ ಫಿರ್ಯಾದುದಾರರು ನೋಡಿ ಪರಿಚಯ.
Yes, my lord. Sir, from 7 years they know each other. That is what is the position by the respondent. But cross-examination, my lord. It starts with ನಾನು ಮಹಾನಗರ ಪಾಲಿಕೆಯಲ್ಲಿ, my lord.
Yes.
This is dated 3/5/2010. ನಾನು ಮಹಾನಗರ ಪಾಲಿಕೆ ಗುತ್ತಿಗೆದಾರನಾಗಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೇನೆ. ನನಗೆ ಗುತ್ತಿಗೆದಾರನಾಗಿ ಕೆಲಸ ಮಾಡುವ ಬಗ್ಗೆ ಪರವಾನಗಿ ಪಡೆದುಕೊಂಡಿದ್ದೇನೆ. ನನ್ನ ಕೈ ಕೆಳಗೆ 25 ಜನ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದಾರೆ. ನನಗೆ ಸದರಿ ಗುತ್ತಿಗೆ ಕೆಲಸದಿಂದ ವಾರದ ವಹಿವಾಟು 1 ಲಕ್ಷ ರೂನಷ್ಟು ಇರುತ್ತದೆ ಎಂದರೆ ಅಷ್ಟು ಇರಬಹುದು, ಅದಕ್ಕಿಂತ ಕಡಿಮೆ ಕೂಡ ಇರಬಹುದು ಎಂದು ಉತ್ತರಿಸುತ್ತಾರೆ. ನಾನು ಮಾಡಿದ ಗುತ್ತಿಗೆ ಕೆಲಸಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ನನಗೆ ಬರುವ ಸಂಬಳ ಚೆಕ್ ಮುಖೇನ ಬರುತ್ತದೆ. ನಾನು ವರಮಾನಕರ ಪಾವತಿ ಮಾಡುತ್ತೇನೆ. ಆ ಬಗ್ಗೆ ದಾಖಲೆ ಇದ್ದು ಅದನ್ನು ಹಾಜರು ಮಾಡಬಹುದು. ಫಿರ್ಯಾದಿಯನ್ನು ನಾನು ಪ್ರಥಮ ಬಾರಿಗೆ ಬಂದರು ಪ್ರದೇಶದಲ್ಲಿ ಮೆಟೀರಿಯಲ್ಸ್ ಕೊಂಡುಕೊಳ್ಳುವ ಸಂದರ್ಭದಲ್ಲಿ ನೋಡಿರುತ್ತೇನೆ. ನಾನು ಬಂದರಿನ ಅಜೀಜುದ್ದೀನ್ ರಸ್ತೆಯ ನಿವಾಸಿ ಅಲ್ಲ. ನೆಲ್ಲಿಕಾಯಿ ರಸ್ತೆ ಬಂದರು ಏರಿಯಾದಲ್ಲಿ ಎಂದರೆ ಸರಿ. ನ್ಯಾಯಾಲಯದ ಕರೆಯಲ್ಲಿ ಕಾಣಿಸಿರುವ ವಿಳಾಸ ನನಗೆ ಸಂಬಂಧಿಸಿದ್ದಲ್ಲ. ನನ್ನನ್ನು ಪೊಲೀಸಿನವರು ಮಾರುಕಟ್ಟೆಯಲ್ಲಿ ದಸ್ತಗಿರಿ ಮಾಡಿದ ನಂತರವೇ ನಾನು ಈ ಕೇಸಿನಲ್ಲಿ ಹಾಜರಾಗಿರುವುದು. ನನ್ನ ಪರವಾಗಿ ಕೇಸ್ ನಡೆಸಲು ವಕೀಲರಿಗೆ ವಕಾಲತ್ನಾಮೆ ಕೊಡಲಿಲ್ಲ ಎಂದರೆ ಸರಿ. ನನ್ನ ಮುಖ್ಯ ವಿಚಾರಣೆಯಲ್ಲಿ ಚೆಕ್ ಪುಸ್ತಕ, ಪಾಲ್ ಪುಸ್ತಕ, ಸ್ಟ್ಯಾಂಪು ಮತ್ತು ನನ್ನ ಪರ್ಸ್ ಕಳೆದು ಹೋಗಿದೆ. ಆ ಕಾರಣ ನಿಶಾನ ಈ ಒಂದು ಚೆಕ್ಕಿನ ಮೇಲೆ ಸ್ಟಾಪ್ ಪೇಮೆಂಟ್ ಮಾಡುವಂತೆ ಬ್ಯಾಂಕಿಗೆ ಹೇಳಿದೆಂದು ಸಾಕ್ಷ್ಯ ನುಡಿದಿರುತ್ತೇನೆ. ಆ ರೀತಿ ನಾನು ಸ್ಟಾಪ್ ಪೇಮೆಂಟ್ ಮಾಡಲು 2005ನೇ ಇಸ್ವಿಯಲ್ಲಿ ತಿಂಗಳು ನೆನಪಿಲ್ಲ, ದಿನಾಂಕ 27ನೇ ತಾರೀಕಿನಂದು ನಿರ್ದೇಶಿಸಿರುತ್ತೇನೆ. ಸದರಿ ಮೇಲೆ ಹೇಳಿದವುಗಳು ಬಂದೂರು ಪ್ರದೇಶದಲ್ಲಿಯೇ ಕಾಣೆಯಾಗಿರುತ್ತದೆ. ಚೆಕ್ ಪುಸ್ತಕದಲ್ಲಿ 3 ಚೆಕ್ಗಳು ಕಳೆದು ಹೋಗಿವೆ ಎಂದು ನಾನು ಬಂದೂರು ಠಾಣೆಯಲ್ಲಿ ದೂರು ಸಲ್ಲಿಸಿರುತ್ತೇನೆ. ನನ್ನ 3 ಚೆಕ್ಗಳು ಕಳೆದು ಹೋದ ಬಗ್ಗೆ ಠಾಣೆ ಕೊಟ್ಟ ದೂರಿನ ಮೇಲೆ ಪ್ರಥಮೋತ್ತಮನವರೇ ದಾಖಲು ಮಾಡಿದ ಬಗ್ಗೆ ಯಾವುದೇ ಜಾಹೀರಾತನ್ನು ನಾನು ಪೇಪರ್ನಲ್ಲಿ ಪ್ರಕಟಣೆಗೊಳಿಸಲಿಲ್ಲ. ನಾನು ಪೊಲೀಸ್ನವರಿಗೆ ಕೊಟ್ಟ ದೂರಿನ ಬಗ್ಗೆ ದೂರಿನ ಕಾಪಿಯನ್ನು ಹಾಜರು ಮಾಡಿಲ್ಲ. ಕಳೆದು ಹೋಗಿರೋ 3 ಚೆಕ್ಗಳ ನಂಬರ್ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಕಳೆದು ಹೋದ ಚೆಕ್ಗಳ ಮೇಲೆ ಸ್ಟಾಪ್ ಪೇಮೆಂಟ್ ಮಾಡುವಂತೆ ಬ್ಯಾಂಕಿಗೆ ನಿರ್ದೇಶಿಸಿದ ಪತ್ರದಲ್ಲಿ ಸದರಿ 3 ಚೆಕ್ಗಳ ನಂಬರ್ಗಳನ್ನು ನಮೂದು ಮಾಡಿರುತ್ತೇನೆ. ಬ್ಯಾಂಕಿಗೆ ಕೊಟ್ಟ ಪತ್ರಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಹಿಂಬರದ ಮೂಲ ಪ್ರತಿ ಕಾಣೆಯಾಗಿರುತ್ತದೆ. ಚೆಕ್ಕಿನ ಮೇಲೆ ಸ್ಟಾಪ್ ಪೇಮೆಂಟ್ ಮಾಡಲು ನಾನು ದಿನಾಂಕ 27 ತಿಂಗಳು ನೆನಪಿಲ್ಲ
2000 ಬ್ಯಾಂಕಿಗೆ ಕೊಟ್ಟ ಪತ್ರಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಹಿಂಬರಹದ ಮೂಲ ಪ್ರತಿ ಕಾಣೆಯಾಗಿರುತ್ತದೆ. ಯು ಡೋಂಟ್ ಹ್ಯಾವ್ ದ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್.
No, that is why my lord manager was called in and he recognizes that exhibit P1, my lord, which I took my lord to the DW2. ನಿಶಾನೆ D1ರಲ್ಲಿ ಇರುವ ಸಹಿ ನನ್ನದೇ. ನಿಶಾನೆ P1 ಚೆಕ್ ಬಗ್ಗೆ ಬ್ಯಾಂಕಿನವರು ನನಗೆ ದೂರವಾಣಿ ಮುಖಾಂತರ ತಿಳಿಸಿದ ನಂತರ ನಾನು ಬ್ಯಾಂಕಿಗೆ ಅಂದರೆ ಕರ್ನಾಟಕ ಬ್ಯಾಂಕಿಗೆ ಹೋಗಿ ನೋಡಿರುತ್ತೇನೆ. ಸದರಿ ಚೆಕ್ ಹೇಗೆ ಎಲ್ಲಿಂದ ಯಾರಿಂದ ಬಂತು ಎಂಬ ಬಗ್ಗೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನಿಶಾನೆ P1 ಚೆಕ್ಕಿನ ಬಗ್ಗೆ ಮ್ಯಾನೇಜರ್ ಅವರು 6,000 ಮೊತ್ತ ಇದ್ದು 6ರ ಹಿಂದೆ 7 ಎಂಬುದನ್ನು ಸೇರಿಸಿದ್ದಾರೆಂಬ ಅನುಮಾನ ಬರುತ್ತದೆ ಎಂಬ ಬಗ್ಗೆ ನನಗೆ ತಿಳಿಸಿದರು. ನಿಶಾನೆ P1 ಮ್ಯಾನೇಜರ್ ಅವರು ಆ ಬಗ್ಗೆ ತಿಳಿಸಿದ ನಂತರ ಬಂದರು ಠಾಣೆಗೆ ದೂರು ಕೊಟ್ಟಿರುತ್ತೇನೆ. ನಿಶಾನೆ P1 ಚೆಕ್ಕಿನಲ್ಲಿ ಮಾತ್ರ 6,000 ಬರೆದು ಉಳಿದ 2 ಚೆಕ್ಗಳು ಖಾಲಿಯಾಗಿಯೇ ಇದ್ದವು. ನಾನು ಫಿರ್ಯಾದಿ ಅಂಗಡಿಯಿಂದ ಯಾವುದೇ ವಸ್ತುಗಳ ಖರೀದಿ ಮಾಡಿಲ್ಲ. ಪ್ರಾಸ 2 ಮತ್ತು ಪ್ರಾಸ 3 ಅವರ ಪರಿಚಯ ನನಗಿಲ್ಲ. ನಾನು ಕೊಟ್ಟ ದೂರಿನ ಮೇಲೆ ಪೊಲೀಸನವರು ಫಿರ್ಯಾದಿಯನ್ನು ವಿಚಾರಣೆ ಮಾಡಿರುತ್ತಾರೆ. ಸದರಿ ಪೊಲೀಸಿನವರು ಮಾಡಿದಂತ ವಿಚಾರಣೆಯಲ್ಲಿ ಫಿರ್ಯಾದಿ ಚೆಕ್ ಅನ್ನು ಹಿಂತಿರುಗಿಸಲು ಒಪ್ಪಿದ್ದರು. ಮುಂದುವರೆದ ಪಾಲಿಸಲು ಸುವರ್ಣ ಫರ್ದರ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್. ಬಂದರ್ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಫಿರ್ಯಾದಿ ಮತ್ತು ನನ್ನ ನಡುವೆ ಮಾತುಕತೆ ಆದ ನಂತರ ಪೊಲೀಸಿನವರು 1 ವಾರದೊಳಗೆ ಚೆಕ್ ಅನ್ನು ಮರಳಿಸುವಂತೆ ಫಿರ್ಯಾದಿಗೆ ಹೇಳಿದ್ದರು. 1 ವಾರದ ನಂತರ ಠಾಣೆಗೆ ಬರುವಂತೆ ಪೊಲೀಸರು ಹೇಳಿದ್ದರ ಮೇರೆಗೆ ನಾನು 1 ವಾರ ಕಳೆದು ಠಾಣೆಗೆ ಹೋಗಿದ್ದೆ. ನನ್ನ ಮತ್ತು ಫಿರ್ಯಾದಿದಾರರ ವ್ಯವಹಾರವನ್ನು ಮುಕ್ತಾಯಗೊಳಿಸಿದ ಬಂದರು ಠಾಣೆಯ ಪೊಲೀಸ್ನವರ ಹೆಸರು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ನನಗೆ ಮಾತುಕತೆಯಂತೆ ಫಿರ್ಯಾದಿ 1 ವಾರದೊಳಗೆ ಚೆಕ್ ಅನ್ನು ಮರಳಿಸದೇ ಇದ್ದ ಬಗ್ಗೆ ನಾನು ಫಿರ್ಯಾದಿ ವಿರುದ್ಧ ಯಾವುದೇ ಕ್ರಮ ಕೈಗೊಳ್ಳಲಿಲ್ಲ. ಆ ಬಗ್ಗೆ ತಿಳುವಳಿಕೆ ಪತ್ರ ಕೊಡುವಂತೆ ನನ್ನ ವಕೀಲರಲ್ಲಿ ಸಹ ಹೇಳಲಿಲ್ಲ. ಬಂದರು ಪೊಲೀಸ್ ಠಾಣೆಯ ಪೊಲೀಸಿನವರು ನನ್ನನ್ನು ಈ ಕೇಸಿನಲ್ಲಿ ದೂರು ಕಟ್ಟೆಯ ಬಳಿ ದಸ್ತಗಿರಿ ಮಾಡುವ ಪೂರ್ವದಲ್ಲಿ ನನ್ನನ್ನು ಕಾಣಲಿಲ್ಲ. ಸಾರಿ, 3 ಕಟ್ಟೆ ಸಾಕ್ಷಿಗೆ ಈ ಕೇಸಿನ ನ್ಯಾಯಾಲಯದ ಕರೆಯನ್ನು ಸಾಕ್ಷಿಗೆ ತೋರಿಸಲಾಗಿ ಅದರ ಮೇಲೆ ಇರುವ ಸಹಿ ನಿಮ್ಮದ ಎಂದು ಹೇಳಲಾಗಿ ಆರೋಪಿ ಸಹಿ ನನ್ನದೇ ಎಂದು ಒಪ್ಪಿಕೊಂಡಿದ್ದರ ಮೇಲೆಗೆ ಸದರಿ ದಾಖಲೆಯನ್ನು ನಿಶಾನೆ P1 ನಿಶಾನೆ C1 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಸಾಕ್ಷಿಯ ಸಹಿಯನ್ನು ನಿಶಾನೆ C1A ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ನಿಶಾನೆ C1ರಲ್ಲಿ ಕಾಣಿಸಿರುವ ವಿಳಾಸಕ್ಕೆ ನ್ಯಾಯಾಲಯದ ಕರೆ ನನಗೆ ತಲುಪಿದೆ ಎಂದರೆ ಸರಿ. ನಿಶಾನೆ C1 ಅನ್ನು ತಾನೇ ಖುದ್ದಾಗಿ ಪಡೆದುಕೊಂಡಿರುತ್ತೇನೆ. ಕರ್ನಾಟಕ ಬ್ಯಾಂಕ್ ಡೊಂಗರಕೇರಿನಲ್ಲಿರುವ ಖಾತೆಯನ್ನು ಬಿಟ್ಟು ಬೇರೆ ಯಾವುದೇ ಬ್ಯಾಂಕಿನಲ್ಲಿ ನನಗೆ ಸೇರಿದ ಖಾತೆ ಇಲ್ಲ. ಬೈಕಂಪಾಡಿಯಲ್ಲಿರುವ ಇಂಡಿಯನ್ ಇಂಜಿನಿಯರಿಂಗ್ ವರ್ಕ್ಸ್ ಇದರ ಮಾಲೀಕ ನಾನೇ ಆಗಿರುತ್ತೇನೆ. ಬೈಕಂಪಾಡಿಯಲ್ಲಿರುವ ನನ್ನ ಇಂಜಿನಿಯರಿಂಗ್ ವರ್ಕ್ಸ್ ಖಾತೆ ಕರ್ನಾಟಕ ಬ್ಯಾಂಕ್ ಡೊಂಗರಕೇರಿ ಶಾಖೆಯಲ್ಲಿ ಇರುತ್ತದೆ. ಕರ್ನಾಟಕ ಬ್ಯಾಂಕ್ನಲ್ಲಿರುವ ನನ್ನ ಖಾತೆ ಕರೆಂಟ್ ಅಕೌಂಟ್ ಆಗಿರುತ್ತದೆ. ನಿಶಾನೆ P1 ಚೆಕ್ ನನ್ನ ಸಂಸ್ಥೆಗೆ ಸೇರಿದ ಚೆಕ್ ಅಲ್ಲ. ಸದರಿ ಚೆಕ್ ನನ್ನ ಸ್ವಂತ ಚೆಕ್ ಆಗಿರುತ್ತದೆ. ನಿಶಾನೆ P1 ಚೆಕ್ಕಿಗೂ ಬೈಕಂಪಾಡಿಯಲ್ಲಿರುವ ನನ್ನ ಸಂಸ್ಥೆಯ ಖಾತೆಗೂ ಯಾವುದೇ ಸಂಬಂಧವಿಲ್ಲ. ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ನಡೆದ ಪಂಚಾಯತ್ನಲ್ಲಿ ಹಾಜರಿದ್ದ ಕಾರ್ಪೊರೇಟರ್ ಜಗದೀಶ ಮತ್ತು ಜಗದೀಶ್ ಗೌಡರನ್ನು ಸಾಕ್ಷಿದಾರರನ್ನಾಗಿ ಮಾಡಲು ನನ್ನದೇನೂ ಅಭ್ಯಂತರವಿಲ್ಲ. ನಾನು ಮೇಲೆ ಹೇಳಿದ ಸಂಗತಿಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಯಾವುದೇ ದಾಖಲೆಗಳನ್ನು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಹಾಜರು ಮಾಡಿದಂತೆ ಸರಿ. ಮೆಟಲ್ ಡೆಕೋರೇಟರ್ ಅಂಗಡಿ ಸಂತೆಗಲ್ಲಿನಲ್ಲಿರುವ ನನ್ನ ಮನೆಯ ಎದುರುಗಡೆಯಲ್ಲಿಯೇ ಇರುತ್ತದೆ ಎಂದರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನಾನು ನೆಲ್ಲಿಕಾಯಿ ರಸ್ತೆಯಲ್ಲಿರುವ ಕುನಿಲ್ ಟವರ್ಸ್ಗೆ ನನ್ನ ವಾಸ್ತವ್ಯವನ್ನು ಸ್ಥಳಾಂತರಿಸಿ ಸುಮಾರು 10 ವರ್ಷವಾಯಿತು. ಸಂತೆಗಲ್ಲಿಯಲ್ಲಿರುವ ನನ್ನ ಹಿಂದಿನ ಮನೆಯಿಂದ ನಾನು ಈಗ ವಾಸ ಇರುವ ಕುನಿಲ್ ಟವರ್ಸ್ಗೆ ಅಂತರ ಸುಮಾರು 10-15 ಅಡಿಗಳಿರಬಹುದು ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನಾನು ಸಂತೆಗಲ್ಲಿಯಿಂದ this is regarding receipt of notice. The defense was taken that the notice was not served. Therefore, this part of the cross-examination was done by the advocate for the respondent. Now, my lord, the third person whom the cross-examination they asked for, this Jagdish Gowda, was also examined, my lord, as the DW3.
Yes.
Who says that, my lord, there was a complaint in the station. He accompanied the petitioner. May I read this small evidence, my lord? ಈಗ ಸುಮಾರು 7-8 ವರ್ಷಗಳಿಂದ ನಾನು ಮಣ್ಣು ಜಲ್ಲಿ ವ್ಯಾಪಾರ ಮಾಡುತ್ತಿದ್ದೇನೆ. ಆರೋಪಿ ಪರಿಚಯ ನನಗಿದೆ. DW3 ಮನೆ.
Yes.
ನನಗೆ ಫಿರ್ಯಾದಿದಾರರ ಪರಿಚಯ ಆಗಿರುತ್ತದೆ. ಬಂದರ್ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಆರೋಪಿಯ ಚೆಕ್ ಕಳೆದು ಹೋಗಿತ್ತು. ಸದರಿ ಚೆಕ್ ಈ ಕೇಸಿನ ಫಿರ್ಯಾದಿದಾರರಿಗೆ ಸಿಕ್ಕಿದ್ದು. ಆ ಸಂಬಂಧ ಪೊಲೀಸ್ನವರು ಸದರಿ ಚೆಕ್ ಅನ್ನು ಆರೋಪಿಗೆ ಮರಳಿಸುವಂತೆ ಫಿರ್ಯಾದಿದಾರರಿಗೆ ತಿಳಿಸಿದರು. ಫಿರ್ಯಾದಿದಾರರು ಸದರಿ ಚೆಕ್ ಅನ್ನು ಕೊಡುತ್ತಾರೆ, ತೆಗೆದುಕೊಳ್ಳಿ ಎಂದು ಯಾವುದೇ ಫಿರ್ಯಾದಿಯನ್ನು ದಾಖಲು ಮಾಡಿಕೊಳ್ಳದೆ ನನ್ನನ್ನು ಮತ್ತು ಆರೋಪಿಯನ್ನು ಕಳಿಸಿದ್ದರು. ಆ ನಂತರ ಈ ಕೇಸಿನ ಬಗ್ಗೆ ಕರೆಯಲಿಲ್ಲ. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್. The learned magistrate proceeds on the base check is returned because of the stop payment. Though manager admits before the court below that
Where is the endorsement?
there is a discrepancy in the check and P2.
What is the reason for dishonor? What is the reason for dishonor?
Stop payment.
Illegal.
Stop payment. For kindly see exhibit P2, my lord. Payment stopped by the draw.
Where is exhibit D1? Please read exhibit D1.
I'm sorry, my lords, I don't have exhibit D1.
Yeah, ಗೊತ್ತಾಗಲ್ಲ. ಏನ್ ಕಳ್ಸಿದ್ರೆ exhibit D1 is simply illegible.
Well, probably that is the reason why they have not issued a certified copy for my counterpart, my lord. I have all other exhibits except exhibit D1 and D2, my lord.
No, it is fully blank. Maybe this is a fax copy that you sent. Stop payment.
That is the only one exhibit which is marked on our behalf, my lord.
How does the trial court deal with this?
Because trial court says that I have not produced any document to show that there was sufficient money in my account. Therefore, my lord, it is stopped payment. Therefore, 138 attracts.
Yes.
No, it's a current account check, my lord. It is not a savings bank account check.
Who has said it's a current account?
This manager himself.
Where does he say that?
Yes, I'll take money. Overdue account. It's a check of a overdue account. I'll
Please
take my
read.
loss for that. Overdraft account.
ಎಲ್ಲಿದೆ ಓದ್?
ಬಂದಿದೆ. Lords, kindly see cross-examination, my lord, of DW2.
Yes.
Lord, 4 lines from the top, my lord. ನಮ್ಮ ಶಾಖೆಯಲ್ಲಿ ಹೆಚ್ಚಿನ ಹಣಕಾಸು ವ್ಯವಹಾರ ಮಾಡುವವರ ಪರಿಚಯ ನಮಗಿರುತ್ತದೆ. ಆರೋಪಿಗೆ ಸಂಬಂಧಿಸಿದ 3 ಖಾತೆಗಳು ನಮ್ಮಲ್ಲಿದ್ದು ಆರೋಪಿಯ ಓಡಿ ಖಾತೆ ನಂಬರ್ 1327 ಆಗಿರುತ್ತದೆ.
ಹೌದು.
ಉಳಿದ ಉಳಿತಾಯ ಮತ್ತು ಠೇವಣಿ ಖಾತೆ ನಂಬರ್ ನನಗೆ ನೆನಪಿಲ್ಲ. So this check was issued on this 1327.
Account number 1327.
Yes, no. It is a overdraft account.
ಎಲ್ಲಿದೆ 13 account number?
Exhibit P1, my lord. Check itself.
1327.
1327.
Then you please come to the evidence of PW2.
My lord.
Please come to the evidence of PW2.
PW2 is his friend, my lord. Respondent's friend is PW2.
Yes.
And our Bhavana PW3 anta madidare.
Yes.
They all the three say in the same line. English PW2, he is not a friend of the respondent, that is a complainant.
Who is Mr. Imtiaz? Or Imtiaz is the yes, how does the trial court deal with this?
But trial, that is the reason. The trial court says, my lords, that I have not shown that there is sufficient money in the account. And I have not prepondered the probabilities. Therefore, my lords, it is presumed that I have committed an offense, therefore conviction.
Please, Bapu. The petitioner has challenged the judgment of conviction dated so and so, passed by so and so in CC number 1348 of 2008, convicting him for the offences punished under section 138 of the Negotiable Instruments Act. The consequent sentence directing the petitioner to pay fine of rupees 82,000 and in default to undergo simple imprisonment for a period of 4 months. The petitioner is also agreed with the judgment of the appellate court in criminal appeal. Judgment dated 5/3/2014, passed by the appellate court in criminal appeal 98/2011, by which the judgment of conviction in the order of sentence was upheld. Next paragraph. The private complaint lodged by the respondent herein discloses that we had advanced a loan of rupees 76,000 to the petitioner, and that the petitioner had drawn a check for the said sum of rupees 76,000 from an account bearing number 1327 at Karnataka Bank Limited, Dongarkere, Mangalore. He claimed that the said check, when presented for encashment, was dishonored due to the reason that the payment of the check was stopped by the petitioner. Full stop. The petitioner caused a notice of demand on 29/10/2005, which returned unserved. However, an intimation was delivered to the petitioner. The petitioner neither paid nor replied to the notice and therefore committed an offence under section 138 of the Negotiable Instruments Act. Hence, the respondent lodged prosecution for the offence in section 138 of the Negotiable Instruments Act. Full stop. The petitioner, who was served with the process, pleaded not guilty and claimed to be tried. Stop. The respondent was examined as PW1 and he marked exhibits P12, P5. He also examined 2 other witnesses as PW2 and PW3. Full stop. The statement of the respondent, statement of the petitioner was recorded under section 313 of CRPC to deny the evidence and adduced evidence in defense. Full stop. He was examined as DW1 and he examined the manager of the Lower Bank as DW2 and a witness as DW3 and marked exhibits D1 and D2. Full stop. Based on the oral and documentary evidence, the trial court held that though the check in question was stopped, though the payment of the check in question was stopped by the petitioner, yet, the petitioner had not maintained sufficient balance in his account, and therefore, it held that the petitioner had committed an offence punishable under section 138 of the Negotiable Instruments Act. Full stop. The trial court to service the presumption under section 139 of the Negotiable Instruments Act and held that the petitioner had committed an offence punishable under 138 of the Negotiable Instruments Act and consequently convicted him for the said offence and sentenced him to pay a fine of 82,000 in default to undergo simple imprisonment for a period of 4 months. Stop. An appeal preferred by the petitioner before the appellate court also met the same fate. Being agreed by the same, the present petition is filed. That the learned counsel for the petitioner submitted that exhibit D1 was an intimation furnished by the petitioner to the bank, instructing it to stop the payment. To stop. He submitted that the check in question was issued from the overdraft account of the petitioner. The question of there being the question of the petitioner not having sufficient funds in his overdraft account did not arise. He contended that TW2, who was the manager of the bank, had deposed that the petitioner had submitted a request for stopping the payment of 3 checks, of which the check in question was one of them, and therefore, the offense under section 138 of the negotiable instruments was not committed. We also contended that except the check in question, there is no other document on record to establish the transaction between the petitioner and the respondent. The learned counsel submitted that the trial court decided, the trial court returned a finding that the petitioner was guilty of the offense punishable section 138 of the Negotiable Instruments Act, based on the presumption under section 113 of the Act, and also that the petitioner had not produced any materials to establish that he had sufficient funds in his account to honor the check in question. To stop. He contended that the evidence of PW2 and PW3 were inconsequential as the petitioner did not produce any material to establish the transaction between the petitioner and the respondent. To stop. The respondent, though served with the notice of the revision petition, has not entailed appearance. Next, I have produced the records of the trial court as well as the judgment of records, the judgment of the trial court as well as the judgment of the appellate court. Next one. A perusal of the records would disclose that the petitioner claimed that he had advanced a loan of up to 76,000 to the petitioner claimed that the respondent claimed. Respondent claimed that he had advanced a loan of up to 76,000 to the petitioner, and that in discharge of the said loan, petitioner had handed over the check in question for a sum of rupees 76,000. The check was presented, 76,000. The check was dated 23/10/2005. And the same was dishonored on 27/10/2005. As the payment of the check was stopped by the drawer, namely the petitioner here. So the evidence of DW2 indicate that the check in question was drawn from the overdraft account of the petitioner, and therefore, it cannot be claimed that the petitioner did not have sufficient funds in his account to honor the check. To stop. DW2 specifically stated that even before the check in question was presented for encashment, the petitioner had already submitted a letter to stop the payment of 3 checks, including the one in question. To stop. Therefore, the petitioner had effectively rebutted the presumption under section 113 of the Negotiable Instruments Act, and it was for the petitioner to establish it was for the respondent to establish by acceptable evidence about the transaction between the petitioner and the respondent, about the previous transaction between the petitioner and the respondent, and that the check in question was drawn by the petitioner towards discharge of the said debt. To stop. The evidence of PW2 and PW3 PW2 and PW3 were interested witnesses who merely claimed that the amount of up to 76,000 was paid in their presence. Full stop. It is seen that PW2 was a close friend of the petitioner and PW3 was his brother-in-law. Full stop. The statement, the deposition of PW2 and PW3 did not demonstrate the transaction between the petitioner and the respondent. Having regard to the fact that the respondent had claimed, the petitioner had claimed that the check in question was lost and had therefore intimated the drawer bank to stop the payment of the said check. Full stop. In that view of the matter, the trial court and the appellate court have the trial court and the appellate court have misjudged the case by applying the presumption under section 139 of the Negotiable Instruments Act and to hold that the petitioner had not rebutted the presumption, notwithstanding the fact that DW3 being the bank manager had specifically deposed before the court that the petitioner had directed the stoppage of the payment of the check in question. To stop in that view of the matter, the trial court and the first appellate court committed an apparent error in convicting the petitioner for the said offence. To stop hence the following order, this revision petition is allowed. The interim judgment of conviction passed by so-and-so, dated so-and-so, in so-and-so, and the consequent order of sentence directing the petitioner to pay a fine of rupees 82,000 and in default to undergo simple imprisonment for a period of 4 months is set aside. Consequently, the judgment dated so-and-so passed by the so-and-so in criminal appeal number so-and-so is also set aside. Yes.
That's it.
Please wait, Mr. Are you in a hurry? Got some film movie tickets. Then please wait. I am not in a hurry. ಏನಿದೆ Samir SN. There is no representation for the petitioner. Just a check amount. The first time ಬರ್ತಿರೋದು ಹಿಂದೆ ರೀಚ್ ಆಗಿಲ್ಲ ಯಾವಾಗನು ಹಿಂದೆ ಯಾವ್ದು ರೀಚ್ ಆಗಿಲ್ಲ. There is no representation for the petitioner as a last chance discount on date. Girisha NR. Girisha NR. It's made clear that no adjournment will be granted on next. Same order. B promote. Yes, an offense. Yes. I heard. Who are the witnesses? Hostile. Complaint is turned hostile. Eyewitness. Hostile. What does it say? So the accused was driving the tractor. So he admits that this accused was one of the drivers. PW10? No.
PW11, easy. Part in motion. Inform the idea.
Yes. Yes, please. PW5 ಓದ್ಬೇಕಲ್ಲ ಫಸ್ಟ್.
ನನಗೆ ಆರೋಪಿ ಸುಮಾರು 3 ಹಿಂದೆ ಈ ವಿಷಯವನ್ನು ನನ್ನ ತಮ್ಮ ನನಗೆ ತಿಳಿಸಿದೆ.
Yes.
ನಾನು
Who are the eyewitnesses? PW2. PW2 was. No. Hmm. Hmm. Who's the master and exhibit? Yeah. Go to the minimum. ಮೂರು ತಿಂಗಳ ಕಾಲ ಸಾಗುವ ಶಿಕ್ಷೆಯನ್ನು ಅನುಭವಿಸತಕ್ಕ Yes, Mr. Srinivas. PW2, PW3 and PW6, they all support.
PW3, again, PW3 and PW6. PW6 is a student who had recorded.
13 years old girl.
All these things. The complaint shares the complaint and other.
Doesn't matter. Fact is the accident has occurred and he has died. Question is whether in the manner described by PW 2, 3 and 6 or in some other way. Death is not in dispute.
That is not disputed. That is not disputed.
Uh,
Manner of the accident.
And the way they prosecution verified the appears it is not so as.
Maybe. Kalsi more. Is this tomorrow? File kalsi. He should take on some defenses. Sudden banda, uduga, old banda, cross marda. I mean, the 302. The problem is in 304A, you people take a defense like in 302. Non-committal, absolutely non-committal. What would have happened if you had said that I was driving, this boy suddenly came, I couldn't control. That is how you should take a defense. But you ಎಲ್ಲಾನು deny ಮಾಡ್ಕೊಂಡು ಹೋದ್ರೆ this is what happens. 304 ಅಲ್ಲಿ you should take a defense because there is a death. ನೋಡಿ ನಾಳೆ ಹಾಕಿ ನೋಡಿ. Next. Yes. ಏನಾಗ್ಲಿಲ್ವಾ? No settlement. ಇದಲ್ವಾ? Yes. ಏನ್ ಚೆಕ್ ಅಮೌಂಟ್ ಏನು? ಫಸ್ಟ್ ಕೇಸ್ ಎಷ್ಟು? What is same parties? What is the purpose for which the check was drawn? Yes. Like that, Lakshmi glass and plywood yaar ninga. Yes. I think bank ಅಲ್ಲಿ ಯಾವ ಅಡ್ರೆಸ್ ಇದೆ? ಬ್ಯಾಂಕ್ ನಿಮ್ಮ ಅಕೌಂಟ್ ಈ ಅಡ್ರೆಸ್ ಅಲ್ಲಿ ಅಕೌಂಟ್ ಕ್ಲೋಸ್ ಅಂತ. Yes. Exhibit P3 ಏನಂತ? ಏನಂತ ಹೇಳ್ತಾರೆ? ಏನಂತ ಹೇಳ್ತಾರೆ P3 ಅಂತ? So how have we established the transaction? Yeah, admitted. Both. Nature city. Nature is not in dispute. What is there to show the transaction? The check should be issued towards a discharge of a lawful debt. ಅದಕ್ಕೆ ಏನಿದೆ? There should be some bonus 118 ಅಲ್ಲಿ. Presumption ಇದೆ. Provided you establish that there is some transaction. ಏನೋ transaction ತೋರಿಸಿ presumption automatic ಬರುತ್ತೆ. ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತದೆ ತೋರಿಸಿ? DW1 ಓದ್ ಹೇಳ್ತಾರೆ DW1. DW1 ಓದು. Who is Papanna? Papanna ಯಾರು? ಅಲ್ಲ ನಾನು ಪಾಪಣ್ಣನ ಹೆಂಡತಿ ಅಥವಾ ಆನಂದನಿಂದಾಗಲಿ ಚೀಟಿ ಹಣವನ್ನು ಎತ್ತಿಕೊಂಡಿರುವುದಿಲ್ಲ, ಆದರೆ ಪಾಪಣ್ಣ ಇವರ ಚೀಟಿ ಹಣ ಎತ್ತುಕೊಂಡಿರುತ್ತೇನೆ. ಯಾರು ಪಾಪಣ್ಣ ಅಂದ್ರೆ ಯಾರು? ಎತ್ತಿಕೊಂಡಿರುತ್ತೇನೆ. ಆದ್ರೆ ಪಾಪಣ್ಣ ಇವರಿಂದ ಚೀಟಿ ಎತ್ತಿಕೊಂಡಿರುತ್ತೇನೆ. ಏನ್ ಸೆಟಲ್ಮೆಂಟ್ ಏನ ಚಾನ್ಸಸ್ ಇದೆಯಾ? ಈ ಪುಸ್ತಕ ಇಟ್ಕೋಬೇಕು ಅಂತ ಏನಿದೆ ನೋಡಿ. ಸದರಿ ಪುಸ್ತಕವನ್ನು ಸಂಬಂಧಿಸಿದ ಸದಸ್ಯರು ಇಟ್ಟುಕೊಳ್ಳಬೇಕು ಎಂದರೆ ಸರಿ. ಸದರಿ ಚೀಟಿ ಮುಕ್ತಾಯವಾದ ನಂತರ ಪುಸ್ತಕದ ಮೇಲೆ ಮುಕ್ತಾಯದ ಶರ ಬರೆದು ಸಂಬಂಧಿಸಿದ ಸದಸ್ಯರಿಗೆ ಕೊಡಲಾಗುತ್ತದೆ ಎಂದರೆ ಸರಿ. ಸದರಿ ಚೆಲುವರಾಜು ಮತ್ತು ಸಿಂಗ್ರಿಗೌಡ ಒಂದೇ ತಾಯಿಯ ಮಕ್ಕಳು. ಜಂಟಿಯಾಗಿ ಚೀಟಿ ನಡೆಸುತ್ತಿದ್ದರೆ ಜಂಟಿಯ ಕೊಡಬೇಕಾಗಿದೆ ಸರಿಯಲ್ಲ. ಸದರಿ ಸಾಲಕ್ಕೆ ನಾನು ಫಿರ್ಯಾದಿ ಸರಿಯಲ್ಲ. 50,000 ಒಪ್ಕೊಳ್ತೀರಾ ನೀವೇನೆ? Anyway, you accept for 50,000 rupees. This check was given. Sorry. Yes, Mr. Raja. ಕುತ್ಕೊಂಡೆ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ರಿ. ಅವ್ರಿಗೆ ಹೇಳ್ರಿ ಇಷ್ಟು ವರ್ಷದಿಂದ ದುಡ್ಡೇ ಹೋಗಿಲ್ಲ. ಕೇಸ್ ಕೊಟ್ಟಾಗ ನೋಡೇ ಇಲ್ಲ. ಇವಾಗ ಪ್ರಯತ್ನ ಮಾಡಿ. ಸ್ವಲ್ಪ ನಿಮಗೂ ವಿರುದ್ಧ ಇದೆ. Once you admit your liability in respect of 50,000 rupees, unless there is something to show that the check is tampered. If it is for 50,000 rupees, why not for 1,50,000? Is a question. But not the check, not the tamper. The bank has not returned on that ground. So, good settlement ಮಾಡಿ. ಯಾವಾಗ ಹೇಳ್ತೀರಿ? The current counsel for the petition will respond in 6 times to explore the possibility of a settlement list on grateful. Yes. Shankar Shastri. ಯಾವುದು? ಇದೆಯಾ ರವಿಶಂಕರ್? ಎಷ್ಟಾಯ್ತು? ಎಷ್ಟು ಸೆಂಟೆನ್ಸ್? Yes, who appears for the other side? TK Nagesh Kumar. I think we'll only impose modified to fine. This was in 2002. We are in 2022. What do you want to do? And not 30,000 rupees. Nothing they can modify, man. We'll only restrict, we'll only modify the sentence to the extent of maybe a 1 lakh rupees. 60,000 rupees is check amount. So 1 lakh to Marbeku. 40,000 is the fine amount. Then you have to work out, once the court has passed an order of upholding the judgment of conviction and the sentence, we can't review it. Review Baralwala. You don't have any interest. Then we'll only modify the sentence. Work out. The revision petition is allowed in part. The judgment of conviction of the petitioner for the offence punishable by section 138 of the Negotiable Instruments Act is upheld. However, the order of sentence passed by the trial court sentencing the petitioner to undergo simple imprisonment for a period of 6 months and to pay fine of rupees 5,000 and a sum of rupees 1,10,000 to the respondent towards compensation is modified. The accused is sentenced to pay a fine of a sum of rupees 1 lakh, of which a sum of rupees 95,000 shall be released to the respondent as compensation and a sum of rupees 5,000 shall be appropriated to the state as cost. If the petitioner fails to pay the fine within a period of 2 months, he shall undergo simple imprisonment for a period of 3 months. Correct, admission correct. Venkatesh Somareddy, Prasanna Shetty. Why, madam? This is coming up regularly. Last time I happened this. So what is the offence? 138. What is the check amount? Yes, no, will you work out some settlement? As a last chance, learn counsel for the petitioner seek time as a last chance discount on date put. It is made clear that no adjournment shall be granted on the next date of hearing. Yes, Mr. Firoz Nizam. Firoz Nizam. There is no representation for the petitioner. As a last chance list on. Yes, 44. Ramesh Deshpande, Ravindra Deshpande. Yeah? Learned counsel, learned SCGP submits that the petitioner must have already undergone the sentence and that he would ascertain the same. List on 24th. Bhargav. No representation for the petitioner. Last chance discount. Yes. Yes. What is 101? Yes. Page 80. Yeah. Yes.
last pipeline. ಒಂಬತ್ತೆರಡು ವರ್ಷಗಳ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಅಧಿಕಾರಿ this proceeding for only context. Interpretation is not fine because one of the and also relevant portion of page. Children of the school, but still the running of a fish and fish meal. Two separate. I want to against the fish. See, some people was yes. Even this one, so we see a danger conflict. See this conflict application. By the petition. This proceeding Indian not that proceeding. A complaint was filed with the kind of the company who also put a report. But I'm not following your words by reading it. 70 and 71 are the relevant portion.
Yes.
This one before. This report proceeds to hold on of section 20 and not this such one of the provisions of
Page 28.
internal page routine of the engine power. 29 and 30. Because of these provisions.
Yes.
29. Powers of the committee. The committee shall have the authority to dispose of cases. Results describe the basic needs of their company has been instituted. That power to be is what this clause provides that the committee shall have the authority to dispose of cases. Shall also provide for the basic needs. We have been here. We shall have the power to deal with the exclusive all. This next is
No, but if you look at what is the purpose of
but my only request is the the order.
yes.
See the report. See the got to rely upon.
No, but what is the final finding in the criminal appeal?
But the honorable court that the.
So ultimately, 17/6/2017 is the order of closure. So if that is set aside, then so if the committee does not have power in a writ appeal, yes, these are all your right, notwithstanding whatever is contained. We will not say, because save the report, because the report is already set aside by the district court. What is the report now? Now, whether the order passed by the Child Welfare Committee is based on the report, then
Does not find fault.
that is right.
The only the order not of closure.
Who appears on the other side?
What not remains unquestioned. The order not yes.
Your report is under what provision?
But
The report submitted by the Assistant Commissioner.
Assistant Commissioner not that for only to first what the committee has. Page 69.
A69.
The portion is at page 20. All findings on that.
19th January 2017.
Now, this is the cover note. Then the report is the overlay, page 78. The committee.
Under what provision this report is submitted? Then there should be some power, isn't it, to submit even a report? There should be a power.
Or exercise for only under section.
Right, so therefore, even then, we fall back upon section 29. The committee does not have the power. You file a public interest. Then if that is the case, we'll see. Yes, Balkut. The learned counsel for the petitioner, after arguing the petition at length, submits that in respect of the grievance of the petitioner, there is already a writ petition pending in public interest before this court. We therefore praise that the issues raised in this revision petition may be kept open to be considered in the pending public interest litigation. The respondents, those served with the notice, have not appeared. Full stop. The learned HCGP submits that a petition is pending consideration before the division bench of this court regarding the nuisance caused by the, what is this?
The fish cutting unit.
Nuisance caused by the fish cutting unit as well as the fish mill run by the respondents 2 and 3, and therefore, comma, therefore, comma, any order that may be passed in this revision petition would impact the public interest litigation. Next para. Since the petitioner has initiated the public interest or somebody else. Since the petitioners are already before the division bench of this court in a public interest litigation, in WP number 12005 of 2021, it is open for them to urge the same contentions in the pending public interest litigation. The revision petition stands disposed of on the above terms. Mr. N. Radhakrishna. Good evening. The petitioner challenged the judgment of conviction dated also on the order of sentence dated also, convicting the petitioner for the offence under 138 and the order of the sentence and the order sentencing the petitioner to pay fine of rupees also. When the petition was listed for admission, the parties have settled the dispute and have filed an application to section 147 of the Negotiable Instruments Act, in terms of which, the petitioner has agreed to pay and the respondent has agreed to receive a sum of rupees 1,50,000 towards full and end settlement of the amount in this dispute, in this revision petition. Full stop. Really, both of you. Full stop. The respondent who is present in person admits and acknowledges the same. View of the above. Payment yav kododu? Stop. In view of the same, in view of the settlement, the impugned judgment of conviction dated so and so by so and so is set aside. Consequently, the judgment passed by 56th Additional City Civil Session Judge Bengaluru in Criminal Appeal 1163 of 2014 is also set aside. The amount of rupees 1,50,000 which is deposited by the petitioner before the trial court is ordered to be released in favor of the respondent. Yes. And consequently, the petition is acquitted of the offences punished in 6 months. Next. So we are Walraj. Yes. Then counsel for the petitioner submits that the parties are working out a settlement. On 24th, Mr. Srinivas R. ಏನು 324 really Srinivas, there is no representation for the petitioner. Discount. Yes. Muzaffar Ahmad. What are the offences? Yes.
Very more. Or a believer. That time, against sustained injuries. And the driver, without stopping the vehicle, and thereafter immediately was he was impatient and he was succumbed to injuries on weekend 2015. And thereafter, this people was ready for went to the traffic police station to do a large complaint as per the and the purpose of the same, his name was registered in the number 144/2015. And thereafter, this head constable PW6 registered a case and he conducted spot monitor as per exhibit P2 and the spot step as per exhibit P3. And he has also seen spot photos were conducted exhibit P4. And thereafter, he drawn inquest as per exhibit P9. And then handed over the further investigation to PW7, who is the CPI, who issued the PM report, and thereafter FSL report, also the AMA report and filed charge sheet. The accused appeared under the accused defense is total denial. And he has specifically set out a defense that this vehicle was not involved in the accident, no accident by the luggage auto. And these three persons who are PW1, PW PW3 of this deceased Mundi were carrying on painting work in Shettar Vishwanath's house in Ayapata. That is 3-story building work. So at the time of carrying painting work by a ladder and also by a rope, this accident he sustained some minor injuries that to laceration and confusion in his leg and knee. He was admitted to government hospital. The admission, the emergency was recorded. The emergency intimation was sent to police. The traffic police went to the police station and they recorded his statement, stating that it is a self-harm. And the matter was settled between that injured, also this Shivan, Ishmael. Now, he died. And from there, the fabrication of this false case as against the luggage auto started. And intentionally, the emergency intimation, emergency records, case sheet, and all these are suppressed. A new complaint as of 3/10/2015 came to the lodge before the PWC.
In respect of that MLC, was any crime registered?
No crime registered. On record, the witnesses after the PW6 who is the headmaster of the they have recorded the statement and statement was not brought. So evidently, and even there is no head injury. He left the doctor who is PW5 conducted the autopsy was unable to find out the cause of death. So he accepted all these events sent to the FS. The FS was found out that this is a right. External injury or internal injury we have to get either in PM report or in to substantiate my contention, Your Honor, I would like to draw your attention to exhibit P1 itself complaint. That is page number 2.
Then this was to be admitted. So that is the case, huh?
PW4 is the vehicle owner.
PW4 is the vehicle owner. Yeah, okay, Your Honor.
Exhibit P1 was.
P1 is the complaint, Your Honor. So according to the complaint, according to the police head constable, it is a written complaint lodged by the PW1. But according to PW6, according to PW1, it is a statement which is recorded by the police. I want to see page number 2 from above 5th line, madam. ಚಿಕಿತ್ಸೆಗೆ ಜಿಲ್ಲಾ ಆಸ್ಪತ್ರೆಗೆ ಹೋಗಿ ಚಿಕಿತ್ಸೆಗೆ ದಾಖಲೆ ಚಿಕಿತ್ಸೆ ಕೊಡಿಸಿದ್ದು ಸಂಚಾರಿ ಪೊಲೀಸ್ ಠಾಣೆ ಪೊಲೀಸ್ನವರು ಮುರಳಿಯ ಹೇಳಿಕೆಯನ್ನು ಪಡೆಯಲು ಬಂದಾಗ ಮುರಳಿಯು ನನಗೆ ಆಗಿರುವ ಗಾಯಗಳಿಗೆ ಎಕ್ಸ್ರೇ ಮಾಡಿಸಿ ವರದಿ ಬಂದ ನಂತರ ನಾನೇ ಖುದ್ದಾಗಿ ಠಾಣೆಗೆ ಬಂದು ದೂರು ನೀಡಿದ್ದೇನೆ. ಅಲ್ಲಿವರೆಗೆ ಘಟನೆ ಬಗ್ಗೆ ಯಾವುದೇ ಕೇಸ್ ದಾಖಲಿಸಿಲ್ಲ. ಸ್ವತಃ ಈ ದಿನಾಂಕ 3/10/2000.
What is the date of the accident?
1/10. So even to say that he died as an inpatient, there was no material. Where he actually died, what is the treatment given to him? No records produced. Secondly, Your Honor,
What about IO? Did you confront?
Head constable.
Did you confront all these things to IO?
Yes. PW6 is the head constable. He, after knowing that it is a 304A, he conducts entire investigation. The collusion of the complainant and the other two files the last case of the case will be seen in this. Chief examination later, last number 2. PW6 here. That is the head constable. Investigation. Procedural. ದೂರನ್ನು ನಾನು ಓದಿರುತ್ತೇನೆ. ದೂರಿನಲ್ಲಿ ಮುರಳಿಯವರು ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ದಿನಾಂಕ 1/2015 ದಾಖಲಾಗಿರುವುದು ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಯಿಂದ ಬಂದ ಬಗ್ಗೆ ಪರಿಶೀಲನೆ ಮಾಡಿದೆನು. ದಿನಾಂಕ 1ನೇ ತಾರೀಕು MLC intimation ಬಂದಿತ್ತು. ಸದರಿ MLC ಅನ್ನು ಪ್ರಥಮ ವರ್ತಮಾನ ವರದಿಗೆ ಅಸಮರ್ಥತೆಗೆ ಲಗತ್ತಿಸಿಲ್ಲ. MLC ದಾಖಲೆಯಲ್ಲಿ RTA ಅಂತ ಬಂದಿತ್ತು. MLC ಇಂಟಿಮೇಷನ್ ಅನ್ನು ನಾನು ಮುಂದಿನ ತನಿಖೆಯಾಗಿ 2020ರವರೆಗೆ ಕೊಟ್ಟಿದ್ದೇನೆ. ಪ್ರಕರಣ ದಾಖಲಿಸಿಕೊಂಡ ನಂತರ ಮುಂದಿನ ತನಿಖೆಯನ್ನು ನಾನು ಇಂತಹ ಪ್ರಕರಣಗಳಲ್ಲಿ ಮಾಡುವ ಅಧಿಕಾರ ಮೇಲಧಿಕಾರಿಗಳ ಮೌಖಿಕ ಮಾಡಿರುತ್ತೇನೆ. ನನ್ನ ತನಿಖೆಯಲ್ಲಿ ಈ ಅಂಶವನ್ನು ನಾನು ನಮೂದಿಸಿರುವುದಿಲ್ಲ. ದಿನಾಂಕ 1ನೇ ತಾರೀಕಿನ ಆಸ್ಪತ್ರೆಯಿಂದ ಬಂದ MLC ನಾನೇ ಸ್ವೀಕರಿಸಿದ್ದೇನೆ. ನಂತರ ನಾನು ಆಸ್ಪತ್ರೆಗೆ ಹೋಗಿ ಗಾಯಾಳುವನ್ನು ಆಶ್ರಮದಲ್ಲಿ ಕೆಲಸ ಮಾಡುವಾಗ ನನಗೆ ತಿಳಿದು ಬಂದಿದ್ದು ಸರಿಯಲ್ಲ. ರಾಜಿ ಮಾಡಿಕೊಂಡಿದ್ದಾರೆ, ಟೆಸ್ಟ್ ಮಾಡುವುದು ಬೇಡ ಅಂತ ಇದಕ್ಕೆ ನಾನು ವಾಪಸ್ ಬಂದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಹೋದಾಗ ಈ ವಿಷಯವನ್ನು ನಮೂದು ಮಾಡಿದ್ದೇನೆ. ಅವರ ಮನೆಯವರು ಒಬ್ಬರಿಗೊಬ್ಬರು ಶಾಮೀಲಾಗಿ ಸುಮ್ಮನೆ ಅದು ಪರಿಹಾರ ಪಡೆಯುವುದಕ್ಕೋಸ್ಕರ ಸರಿಯಲ್ಲ. ಗಾಯಾಳುಗಳಿಗೆ ವೈದ್ಯಕೀಯ ಚಿಕಿತ್ಸೆಗಳ ಬಗ್ಗೆ ಮತ್ತು MLC ರಿಜಿಸ್ಟ್ರಿಯಲ್ಲಿ ನಮೂದಿಸಿದ ಬಗ್ಗೆ ಮಾಹಿತಿ ಕಲೆ ಹಾಕಿಲ್ಲ. ಅಯ್ಯಪ್ಪ ಸ್ವಾಮಿ ದೇವಸ್ಥಾನದ ಬಳಿ 4 ಕಡೆ ರಸ್ತೆಗಳಿವೆ, ಅಲ್ಲಿ ಅಂಗಡಿಗಳು ಮನೆಗಳು ಇದ್ದು ಅಲ್ಲಿ ಜನರು ಓಡಾಡುತ್ತಾರೆ ಎಂದು ಸರಿ. So only people with 1, 2, 3 are relatives of deceased. No independent witnesses, either party matters.
But what prevented you from reading defense evidence and summoning those documents?
Because I have to show the
Preponderance Allah, not in this case.
all the witnesses.
No, if you say that there is an MLC of a fall from a ladder, you must have got it. That is one of the finest defense that you can never place.
ಇಷ್ಟೆಲ್ಲ fabricate ಮಾಡಿದಾಗ ಅದು available ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಮಾಡೋದು.
Allah, ilde ನೀವು on what basis did you suggest? If those documents are not there, on what basis did you make a suggestion to PW6?
PW6 admits MLC information was came to me and I handed over to PW7.
Allah, RTA ಅಂತ ಅಂದ್ರು. RTA ಗೋ ಮತ್ತೆ fall from a ladder ಗೂ ವ್ಯತ್ಯಾಸ ಇಲ್ವಾ?
MLC information was not produced.
So therefore, if you had that MLC intimation that he had fallen from a ladder, you must have, that is the best defense that you had.
He admits on record even both PW6 and 7 admits.
How old are you? How old are you? What is your age? 54. ಮತ್ತೆ sooner the better ಏನೋ ಒಂದು ತೀರ್ಮಾನ ಮಾಡ್ಬೇಕಲ್ಲ. Accused.
Now he is 44 years.
Admit. Next. Arvind Neglur. Sulasa. TJ Sulasa. Yes, Mr. Arvind. You are Arvind Neglur. ಮತ್ತೆ $59. Your colleague is there. Petitioner ತೀರೋಗಿದಾರ? Learned counsel for the petitioner submits that the petitioner/accused has expired and therefore the proceedings and therefore the criminal prosecution against him has abated. The learned counsel for the respondent is there a counselor yaar is TJ Sulasa. Notary advocate. Is that the counsel or the party? The learned counsel for the respondent is absent. In view of the statement made by the learned counsel for the petitioner, this revision petition has abated. Yes, next. Raj Patil.
And for the respondent in this case,
Yes. There is no representation for the petitioner as a last chance list on. Yes. Kashyap and Naik, Arjuna Giloga. Yes, Kashyap and Naik, Janardhan. Yes. Huh? Settle. ಎಲ್ಲ ಕೇಸಸ್ ಸೇರಿನಾ
This is by accident.
ಫೈಲ್ ಮೆಮೋ ಆರ್ ಸಮಥಿಂಗ್ ಲೈಕ್ ದಟ್ ಒಂದು ಐಎ ಹಾಕಿ ಫೈಲ್ ಐಎ ಯಾವಾಗ ಆರ್ಡರ್ ಮಾಡೋದಕ್ಕೆ ಹಂಗೆಲ್ಲ ಆಗೋದಿಲ್ಲ. So if you enter into settlement, then why hesitate? What is check amount 5 lakhs na? So if I have to upset the judgment of both the courts, there should be something. So therefore, better you file an application 147. Nale no? Day after tomorrow. The Royal Council for the petitioner and respondent submits the parties have amicably settled the dispute. List day after tomorrow to enable them to file appropriate application. Yes. A.R. Ravi Kumar. Revision petition is filed challenging the judgment of conviction and the order of sentence. Judgment of conviction convicting the petitioner for the offence punishable under section 138, the order of and the consequent order of sentence dated so and so in so and so directing him to pay fine of rupees 4,50,000, failing which he was ordered to undergo simple imprisonment for a period of 1 year. And this petition was listed for admission. The parties have filed a joint filed an application in section 147 of the Negotiable Instruments Act, in terms of which, they have agreed to settle the dispute at a sum of 3,50,000. The petitioner and the respondent are present in person and they admit this settlement. Full stop. In view of the same, the revision petition is allowed. The judgment of conviction dated so and so, passed by so and so, in so and so, and the order of sentence directing the petitioner to pay a fine of rupees 4,50,000 is set aside. The petitioner is acquitted of the offences punishable in section 138 of the Negotiable Instruments Act. Consequently, the judgment dated so and so, passed by so and so, and criminal appeal number so and so is also set aside. The respondent is at liberty. The amount of rupees 2,25,000 which is deposited by the petitioner before the trial court is ordered to be released in favor of the respondent herein. Since the balance sum of rupees 1,25,000 is paid to the respondent, the petitioner has paid the fine of rupees 3,50,000 rupees to the respondent, and the same is noted. Sign Madibbo, both of you sign. Yes. Yamuna boy. Suresh, yes. Suresh, yes. Huh? There's no representation. Yesterday check amount. ಯಾವ್ದು? ಎಷ್ಟು? Yeah, for the husband. The loan counsel for the petitioner submits that the petitioner is willing to comply. The order dated 17/11/2017 passed by the Metropolitan Magistrate Traffic Court Roman 4 the criminal miscellaneous 202/2013 to stop. In order to enable the petitioner to comply with the aforesaid undertaking list on date court after 2 weeks. Yes. Shiv Shankar. Kiran. R. Kiran. Aged Arvind. For the petitioner. In case ಹೇಳಿ ಎಷ್ಟಿದೆ 4,43,000. What is the transaction? ಯಾವಾಗ settlement ಯಾವಾಗ? Come with some settlement. Settlement ಆಗಲ್ವಾ? No settlement. Yes, Mr. You have any objection for releasing? You have any objection to release the amount in deposit? The loan counsel for the petitioner seeks time. At this stage, the loan counsel for the respondent seeks an order to release the amount in deposit pursuant to the order passed by this court. Dated 19th February 2021. The loan counsel for the petitioner has no objection to release the said amount. In view of the same, the amount deposited by the petitioner before the trial court pursuant to the order of this court dated also is ordered to be released in care of the respondent, which shall however be subject to the result of this revision petition. List on. Yes, Mr. Lakshmikant K. 67. There is no representation for the petitioner and the respondent. List on. Yes, Mr. Vinay Kumar, ND. Mr. Natraj. Good reason. Issue notice regarding admission. In the meanwhile, 50%. Okay, then. There is no representation for the petitioner and the respondent. This town on date. The MR Balakrishna. Sickness.
Is the matter relating to Karnataka value added tax before the magistrate for presentation, the demand for this tax But the middle period, not be served on the petitioner or the respondent. Their sentence are taken.
This is the stage of the proceeding.
That I did question the validity of the assessment. We can, like the question of the validity assessment. I have no right to question the validity of the. The management has wrongly caused the that there is no solution to question the validity. We can have only one point. Because the demand notice assessment order. It has not been served as per the provisions of 176 of the Karnataka private tax rules. Simple matter. This honorable court.
No, but where is notice of the assessment is not served on you.
Usually they are not served. There is like compulsion.
Yes.
Because
For the respondent, my lord.
You must have any demand against you.
the validity of the demand notice is necessary in order to file a recovery application before the magistrate. So there is no validity of the assessment of demand notice served on the respondent. Simple questions are filed before this honorable court. And this honorable court in simple case had one order that the inquiry is conducted.
So where's the question of, where's the question of the magistrate conduct an inquiry into the assessment?
For the service of demand notice. The legal find that only should be questioned before the magistrate. Assessment notice should not be questioned with the magistrate. Magistrate has no authority.
Correct, a magistrate cannot decide the assessment order. So therefore the question is,
Before the assessment, it is not. They have no find. So only regarding validity of the service of demand notice and assessment.
but what will be the effect if the notice is not served upon you? What will be the effect?
Only thing is, no, the notice should be served.
What is the effect if notice is not served? Can the proceedings be halted?
Notice they are not served.
KBI, value added tax, VAT Act. It's good.
Section 176.
Word, please read. Good.
None of the most. So by giving a tendering, it is such a dealer or his manager or his agent. If such dealer or his manager or agent is not owned by giving it, that is the last known place of business or residence, or by giving a tendering, it is some. The address of such dealer is not known, the district authority was sending it to be by district court. If none of the most outside is starting to the 33, the consequence is not one of place of.
So therefore, what is the consequence if this is not followed? What is the consequence of that provision not being followed?
The provision not to serve the validity of service, all these points should be there. And the magistrate has to decide whether there is valid.
Sir, I understood that. What I am asking you is, if section 176 is not followed, what will be the consequence?
So only consequence is, whatever the recovery application is there, that will be disputed.
Take advantage of it.
Yeah, I not taking advantage.
Take advantage of it for seeking and seek for dismissal. See, if the non-compliance of a statutory provision should result in dismissal of the proceeding, take advantage. No, that is not against, no. That is not against the order, the demand. Demand, before finalizing the demand, you have been notified. You can't make this as a fresh ground. This cannot be a fresh ground. This is only for purpose of recovery. Therefore, if the notice is not served, then the recovery cannot be initiated. So therefore, take advantage of it. Aste. Correct, and dismiss agabekala.
Application. This is correct. It is valid service is judgment report. I give this record. One more similar case, I go progress. Then you are, I think,
Yes, Mr.
Okay. In assessment, 5/4/2019, year of 2012 and 13 and 20, and then 2020 is served in notice.
only by way of my picture, what is the, that is, whether the picture is valid.
What is the demand? What is the demand?
One for the effort paid to extend.
Yes, we can consider granting you the stay provided you deposit some money.
The validity.
Correct, if you want it to be.
Don't demand. You can go in appeal. This is the time.
Yes.
This is third. And we can't say this validity.
Yes.
You go in appeal. Only thing is I
Sir,
have valid service.
To file an appeal, it is not the date from which the magistrate issues a notice.
Only the.
Assessing authority. Correct.
Yes, this is not nice.
Yes. Yeah, take instruction. Find out. Find out whether notice is issued or not. Is that one of the modes of service under 176? A fixture? No, is a fixture 176 or Bharata Nodi. If you can't affix it, then that is not a proper mode of service. Yeah, what is the what is the assessment here? 12, 13, 14, 1 crore, you are still sitting on public money. Have you filed any appeal challenging this assessment order?
I could give the demand notice. They won't take it.
Because these are intelligent ways of doing it.
No,
Were you not notified of the assessment order? Assessment proceedings can be notified Madilva.
demand ಆಗಿಲ್ಲ. ನೋಟಿಫೈ ಮಾಡಿಲ್ಲ. ಕಾರಣ
Yes.
become by margin
Find out, Mr. Get the documents. Let us learn HCGP is directed to secure. Yeah, whoever appears. Learn HCGP is directed to accept notice for the respondent. He is also directed to secure instructions whether the notice of the order of assessment was served upon the petitioner as provided under section 176 of the Karnataka Value Added Tax Act. List on, when do you want it? 31st. Yes. M.R. Balakrishna. Yes, what is the offense? IA1? Issue notice regard 50%. 50% of the fine amount within 4. What is the amount? Within 4 weeks. List on. Yes. Mr. Madhusudan. Annexure G. What extension order? Extermination.
In this matter, the contention of the police authority is saying that he's playing on us. We need to break this. According to the aspect commissioner, in the previous order, only the contract only one time section 18 42 Section 55 and 56 of the Code Act. The offense should be given. Here, they are playing moving parts inside the however. According to this section, crimes can offense within a period of 3 years under section 78, 79 or 80 of this Act. Shall extension order passed. In this matter, only one time, section 80 of the KPI.
ಯಾವುದು section 55
removal of persons about the commitment of 56 as single. So the crimes can offense within the period of 2 years.
The person has been convicted at any time either before or after the commission of this act. Twice of an offense.
Usually, first offense, first offense G. Our crime number 117 or 19 is 87 of KPI. Second time, what they are showing is 122 or 19 is 80 of KPI. Third one is 57 or 22 is 87 of KPI. Only one time. The other thing is the number is important. Because no way is small. Yes. Not only
ಎಲ್ಲರೂ ಕರೆದು ಆಡಿಸ್ತಾರ. Those who lose money in cards, they don't sleep till they recover.
He is not having money to leave his
Maybe this is a better source of income. Who knows? The CGP is directed to accept notice. Interim stay of the impugned order for a period of 2 weeks. This on date.
The opportunity has to be given.
On date. Thermopal. Notice 50% of the fine amount within a period of 8 weeks and 4 weeks. This time. Career password.
May I seek liberty to mention, my lord?
Yes,
Serial number 70, my lord. Serial number 70, my lord.
You're not there, it is adjourned.
At time, my lord, it was disconnected, my lord. That is the problem.
So it is adjourned.
Responded, my lord. I responded 2 times, my lord. They have taken the time. Last occasion.
No, next date I'll bring. Don't miss on the next date.
Please, my lord. Oblige.
This number? I'll ಬಿಡಾಮೆ ಇನ್ನೊಂದು ಡೇಟ್ ನಾಳೆ ನಾಳೆನೋ ನಾಡಿದ್ದು ಕೊಡಿ. ಎಸ್ ಗುಪ್ತಾ, MN ರಘು. Yes. Mr. Gupta. You had all the time from morning till evening. Again, you are still searching.
Not searching.
But please don't quote any judgment. Please come on facts. What has happened to the complaint that you had lodged?
There was I had a nice office that my book the false people go to and then on believe what I like
Sir, I asked you a simple question, sir. What happened to the private complaint that you had earlier lodged, or the private complaint that you had earlier lodged, which was referred to the police for investigation? What happened to that complaint?
No investigation was carried out, you are asking for the trial court after saying, what statement is that?
Sir, you're talking of this next subsequent case. I'm asking of the previous case.
Earlier something also same thing happened, you are asking.
Now, please get your facts straight, sir. I think you're not getting the facts properly. What happened to the first private complaint that you lodged, which was referred to the police for investigation?
Well, all the complaints which I have made have been assured that they will take proper action.
Yes, then before the trial court, before the trial court, please wait, sir, please wait. Before the trial court, is the court fixing any date awaiting the report of the police?
No,
So what happened to that case then?
yes, I have to show statement.
No, you can't be saying that. First, you should say what happened to the first case that you filed. Is a B report filed in that case or not?
Yes, my was is only one. That case was dismissed for police investigation, but the report filed.
A B report is filed. What happened to the B report? Have you challenged it?
No, no, no.
B report is not challenged. If that is the case, how can you file one more complaint against the same person and the police inspector?
For the second part of action,
Yes.
third part of action. The part of action is not finished yet.
So the cause of action for the first PCR is finished.
First check, first offense was finished.
Finished. What is the second offense now?
Second offense was the same type of that you marry or pay me 25 lakhs.
Yes.
Same offense was. Same cause of action is repeated.
So you go on filing PCRs one after the other, giving the same cause of action. So that is not the issue, sir. We have a set of procedure. Sir, we have a set of procedure. First you file a PCR, B report is filed, you accept the B report. Now you go to the police, you file a fresh PCR, saying the same facts and accusing the police of threatening you to pay 25 lakhs to the accused number one. This is the allegation. So therefore, where is the cause of action? What happened to the earlier cause of action?
First check you are asking what conviction is happened. Basically, inquiry was there. For us, that will give on that assurance, we did not press for a plea.
Yes.
Second case when we filed, on the basis of first statement it was.
It has to be dismissed, sir. It has to be dismissed because
We gave more denial of 25 lakh demand, more denial of that, I have been not.
where's the question of no denial? They're yet to be notified. They're yet to be notified of the case. Where's the question of no denial?
I have not given even an opportunity to prove my.
Therefore, you must challenge that B report first.
Here this is second district. Division petition, there was no. It recognized him, this is the first statement.
Yes.
There is no police has not filed any report.
Yes.
But even the court has.
Now, please come to the order. We'll close this case today. Please come to the order.
Yes, yes.
Please come to para 16. Where's your private complaint? Yeah, put it. Where have you mentioned about the police demanding 25 lakhs? Where have you mentioned in your private complaint that this person demanded 25 lakhs? Yes, Mr. Why? How can why an accused in another case cannot be cited as a witness? Your case, some witnesses are cited in the private complaint. The police says that against those witnesses there is some other case, so therefore they cannot be witnesses. Well, Ray, I'm asking you a question of question in general. Who can be a witness? Put the evidence. Who can testify? Where have you said?
Not made by the lady.
Yes. Yes.
But for both cases, you need one and so everything has been taken in one who will not know it. So everything, whatever is stated, stated for both cases.
No, you can't be saying that. The reason is this. The earlier complaint that you lodged was against the accused number 1, alleging certain offences. Now, in respect of that case, a B report is already filed. Now, you are saying that when you went to the police, police forced you to accept the offer made by that lady to pay up some 25 lakhs. So now this is a new cause of action, according to you. Yes. Then you have to remove all the other assertions.
Let me have evidence from the people. Let me go.
Sir, you cannot produce any evidence in respect of which a B report is already filed, accepted by the court.
In this particular appeal, your lordship, court was no B report was filed.
Sir, not in this case, sir. Why don't you understand, sir? Not in this case. In the earlier case that was filed by you, B report is filed. Now you can't lead any evidence in the fresh PCR in respect of those allegations that you have made in the earlier PCR. Please understand this. This is a.
I submit your lordship. There is no estoppel.
No.
There is no estoppel.
No estoppel. No. Please don't argue like this. Please come prepared.
I pray your lordship will be allowed for me.
No. No, you have to.
Both are absent to very briefly.
No, we can't simply allow a case, sir. You restrict your case only to the allegations against accused number 2. Only to that extent will permit you. But if you are saying that you want to revive what was already lost, file a memo. File a memo. File a memo. The PCR will be only limited to the question whether the police compelled you to accept the offer made by this or the demand made by that lady. That is all.
As well as police has created false evidence against me by booking 420. I believe it 10 is the complaint.
What book 420?
420 days
That
for my superior officer.
yes. Please restrict any allegation. Any allegation against accused number 1, please expunge all those allegations. File a memo. 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 Please file a memo. When do you want it? Don't write. It's already 5 o'clock. File it tomorrow. We'll take it up day after tomorrow. Mr. Why are you brought to the court? Yes, take whatever day you want. Right, good. Yes. Huh? No. Yeah. Was the wife of the complainant's brother.
Given by then branch check. And I said, both are legally already
ಅದೆಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರು ನೀವು ಇವಾಗ ಎಂತದೆಲ್ಲ ಆಗೋಯ್ತು ಇದೆಲ್ಲ ಆಗೋಯ್ತಲ್ಲ 2010 ಕಂಪ್ಲೇಂಟ್. ಯು ವಾಂಟ್ ಟು ಅಂಡು ದ ಹೋಲ್ ಥಿಂಗ್ ನೌ. ಸೆಟಲ್ಮೆಂಟ್ ಹೇಳಿ ಎಷ್ಟು? ಸಿಟ್ ಅಂಡ್ ಸೆಟಲ್. What is check amount? 1 lakh. 240 ಹೆಂಗ್ ಮಾಡ್ತಾರೆ? 240 ಹೆಂಗ್ ಮಾಡ್ತಾರೆ ಮಿಸ್ಟರ್ ಚಂದ್ರಚೂಡ? On demand is not the subject matter. 240 ಹೆಂಗ್ ಮಾಡ್ತಾರೆ? 138 ಅಲ್ಲಿ maximum is 2. 1,20,000. ಹೆಂಗಾತಿ ಏನ್ ಇಂಟ್ರೆಸ್ಟ್ ಎಲ್ಲ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡ್ಕೊಂಡು 138 ಅಲ್ಲಿ ಹೆಂಗೆ? ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. 1,20,000 ಇದೆ ರೀ ಗೌಡ್ರೆ. 120 ಇದೆ. ಡಬಲ್ ದಿ ಮಾಡಿದ್ದಾರೆ. 2010 ಇಸ್ವಿ ಕೇಸ್ 2022 ತೀರ್ಮಾನ ಆಗಿದ್ರೆ ಡಬಲ್ ಮಾಡ್ಲೇಬೇಕಲ್ಲ. ಯಾವಾಗ ಸೆಟಲ್ಮೆಂಟ್ ಹೇಳಿ, ಯಾವಾಗ ನೀವು ಹೇಳಿ. ಎಸ್ ಮಿಸ್ಟರ್ ಚಂದ್ರಚೂಡ ಕ್ಲೋಸ್ ಮಾಡಿ. ಯಾವಾಗ? 2013 ಮಿಸ್ಟರ್, ವಿ ಕಾಂಟ್ ಅಡ್ಜರ್ನ್ ಇಟ್. ಒಂದು ಡೇಟ್ ನೀವೇ ಹೇಳಿ. Request of learned counsel for the petitioner, list on also in order to explore the possibility of settlement. Yes. M. Rudraya. Petitioner. ANK offense. 138. Domestic violence. ಎಷ್ಟು? ಅಟ್ಟಿ ಕಾಂಟ್ಯಾಕ್ಟ್ ಇಲ್ಲ. ಎಷ್ಟು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ? 4,000 rupees per month. 4,000 has been reduced to 2,000. ಅದು ಕೊಡಕ್ಕಾಗಲ್ಲ. ಮತ್ತೆ ಇದನ್ನ ದಿವಸ ಅಲ್ರಿ 2,000 ಎಲ್ಲಾಗಿದೆ? ಯಾರು ಅಪೀಲ್ ಆಗಿದೆ? Then we'll dismiss it. Order passing source modified 2,000 rupees towards medical expenses to the respondent. The petitioner has challenged the order, the judgment passed by the fast track court -3 at Mysore, dated 18/2/2013 in criminal appeal 155/2012, by which it modified the order dated 4/8/2012 passed by the JMFC second court close at Mysore in CMS number 588/2009, and directed the petitioner to pay maintenance of a sum of ₹2,000. Maintenance alla. Directed him to pay a sum of ₹2,000 towards the medical expenses to the respondent. Mister, don't mislead the court. ಬರೀ 5,000 ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ರು ಟ್ರಯಲ್ ಕೋರ್ಟ್ನವರು, ಅದನ್ನ 2,000 ರೂಪಾಯಿ ಮಾಡಿದ್ದಾರೆ. 4,000 rupees is confirmed. ಅಲ್ರಿ ಆರ್ಡರ್ ಕಾಪಿ ಓದಕ್ಕಾಗಲ್ವೇನ್ರಿ? ಇಂಗ್ಲಿಷ್ ಬರಲ್ವಾ? The petitioner has challenged the order dated, petitioner challenged the order dated 4/8/2012 passed by the JMFC second court at Mysore in CMS number 588/2009, by which he was directed to pay monthly maintenance of ₹4,000 to the respondent and her daughter, and was also directed to pay ₹5,000 as medical expenses. The petitioner has also challenged The judgment dated 18/2/2013 passed by the Fast Track Court -3 at Mysore in Criminal Appeal 155/2012, by which the order of the trial court granting maintenance of rupees 4,000 per month was confirmed. Next para. The petitioner contended, the respondent filed a petition to section 12(1) of the Domestic Violence Act 2005 in CMS number 588 of 2009 for a full stop. She also sought for an order of maintenance of a sum of rupees 8,000 per month for the maintenance of herself and as well as her daughter, who was then aged 13 years. Full stop. The trial court, after considering the material on record and the ability of the petitioner to pay maintenance, directed him to pay a monthly maintenance of rupees 4,000 per month and medical expenses of rupees 5,000 with cost of rupees 1,000. This was challenged by the petitioner. This was challenged by the petitioner in Criminal Appeal 155/2012. The appellate court confirmed the order of the trial court, but modified the award of rupees 4,000 rupees towards medical expenses to a sum of rupees 2,000. Being agreed by the same 5,000 to a sum of rupees 2,000. Being agreed by the same, the present petition is filed. Next, the learned counsel for the petitioner submits that the petitioner has no confirmed source of income and therefore, the trial court and the appellate court were not justified in granting the maintenance at the rate of rupees 4,000 per month. Having regard to the fact that the petitioner has not disputed his marital relationship with the respondent, number one, and that the daughter and that the petitioner and the respondent have and that the petitioner and that the respondent and that the petitioner and the respondent are not residing together, having regard to the standard of living of the petitioner and the respondent, and also the education needs and necessities of the child, the order passed by the trial court and confirmed by the appellate court do not warrant any interference by this court in revision. Hence, this revision petition lacks merit and the same is dismissed. Any amount in deposit is ordered to be released to the respondent. R.V. Sadashivappa. ಇದೊಂದೇ last pass over. R.V. Sadashivappa. Yeah, what is this 138?
My complaint was dismissed by magistrate.
There is no representation for the petitioner. List on date for short execution. Not tomorrow. List ಆಗಬೇಕಲ್ಲ ನಾಳೆ. List on 20. But admission matters ಎಲ್ಲ time ಹಿಡಿತಾ ಇದ್ವಿ. We are not reaching final hearing. So we have to move the final hearing first.